Good morning, everyone. Welcome to the Judiciary Committee hearing in advance of the second special session of 2021. This is to confirm or to consider nominations. My name is Carl Rhodes. I'm chair of the committee. The Zoom meeting and YouTube live stream event will include the Judiciary Committee's 11 a.m. agenda on two judicial nominations. First is Governor's Message number 1, nominating Daniel M. Gluck to the Intermediate Court of Appeals. And the second is Judiciary Communication number 1, nominating Leslie N. Malloyan to the First Circuit District Family Court. Excuse me. The other members of the committee are the Vice Chair, Cherokee Okolole, Senator Casio, Senator Gabbard, Senator Lee, Senator Kim, and Senator Favela. This meeting is being streamed live on YouTube. You will find links to viewing options for all Senate meetings on the live and on-demand video page of the legislature's website. If you're interested in seeing the written testimony, you can go to the legislature's website, www.capitol.hawaii.gov, and follow the links to the 2021 second special session. And it's a little confusing to get there, but just be sure you're going to the second special session. And then you can look, and if you go to the bill, you can see the written testimony that's been submitted. In the unlikely event that we have to abruptly end this hearing due to major technical difficulties, the committee will reconvene the hearing on Wednesday, July 28 at 9:30 a.m. and a public notice will be posted on the legislature's website. We haven't had that kind of problems for quite some time, so hopefully this isn't the day. For the people testifying remotely, all testifier audio will be muted and video disabled until it is your turn to testify. There's a 2-minute time limit on oral testimony. There'll be a clock that you'll be able to see that counts down. Members may have questions for you, so after your 2 minutes are done, if you can stay around for a while, you may get to speak more depending on whether members would like to hear more from you. If there are temporary technical glitches during your turn to testify, we may have to move on to the next person. We appreciate your understanding and remind you that the committee does have it's already received and read your written testimony. But if we will try to get back to you if it can. I'll be reading a list of people who've submitted written testimony for each measure. We apologize if the closed captioning doesn't accurately transcribe the names or if I butchered the names. If you're interested in seeing the written testimony, as I mentioned before, you can go to the Capitol website, capitol.hawaii.gov. And the first measure in particular has a lot of interest, so I'm going to, with the indulgence of my fellow members, I'll stop about every 10 testifiers and open it up for people to ask questions. And for those testifying, if you can stay around until that point. After that, if you want to leave, that's fine, but it's possible that members will have more questions later, but we'll try to split it up so people don't have to wait a long time to have questions asked of them. And if you're here for JC1 for Ms. Malloyan, I think it's safe to say it's going to be at least 2 hours. So I promise not to start that part of the hearing until 1 o'clock. So if you want to leave and come back at 1, that's fine. You're more than welcome to stay and watch the proceedings before that. But I believe this first part's going to take some time. Okay, with that, let's go ahead and get started. First up on the testifier list is Trevor Awesome, and he is approved for Zoom. Are you here? There you are. Go ahead.
Good morning. I strongly support Mr. Gluck's nomination. I've known and worked with him in a number of contexts, including in his current role at the state ethics office. Each time he's been thoughtful as well as practical in his approach. Just to share one anecdote, recently, there's been some questions by state charter schools about how to operate some of their foundations. And the sort of rules that have been promulgated or discussed at the state charter school office don't necessarily mesh with those of the state ethics laws. And so I contacted Dan and I said, I think we have a problem here. And he took about a day and got back to me and said, hey, look, why don't we try to look at convening a group to meet? We'll bring some expertise from some different areas and try to hammer something out. And I think that's the type of approach that I've seen from him time and time again. And I think it's a personality and an approach that will serve him well on the bench. And that's all. Thank you very much.
Thank you. Next up is Holly Berlin. And, oh, there you are. Good morning. You're still muted.
Thank you. Sorry about that. Good morning. I will stand on my written testimony in support of Daniel Gluck's confirmation to the ICA. Thank you for this opportunity.
Okay, thank you. Next is Jackie Esser.
Not present, Senator.
Okay, she was in support. Pankaj Banat.
Aloha, aloha, Chair. Chair Rhodes, Vice Chair Keho Kalole, members of the committee. My name is Pankaj Banot. I'm testifying in my individual capacity. I'm in strong support of the nomination. Dan has the sufficient legal experience and judicial temperament to serve on the bench of ICA. He's very fair. I have dealt with Dan in his current capacity at the Ethics Commission, and I had some questions, concerns, and opinions about the application of law of ethics to various situations within the state, including the state procurement and other things, and found him to be very fair, very patient, and has tremendous legal acumen and judicial temperament to serve in the position he's nominated for. I have to say is that a lot of comments that are made in public are concerning Dan's qualification. It includes that he's not from here and he's the only white man that got selected and everything that's going on there, and also that he doesn't have sufficient trial experience. I am baffled that we are so stuck on having trial experience, which is not the only criteria to practice law. There are countless examples of very brilliant judicial minds who were appointed to various benches in this country who did not have sufficient trial experience, and one includes Justice Elena Kagan. She had limited number of 5 cases based on my research and review that I have done and followed that particular nomination process. She was the U.S. Senate's attorney. She was appointed Solicitor General of the United States and eventually to the Supreme Court. And if we just simply based it on trial experience, those 5 cases would not amount to much of an experience to be appointed to such prestigious and critical positions in our judiciary in this country. Dan's legal temperament, temperament is amazing. And please support him. Thank you.
Next up is Daphne Barbie Wooten. You're muted, but go ahead. You're still muted. There you go.
Hello? Okay, okay, sorry. Good morning. I'm testifying in support of Daniel Gluck to be appointed to the Intermediate Court of Appeals. I was thrilled when the governor announced his selection. There's very few civil rights attorneys in Hawaii. I know because I'm a civil rights attorney and we meet often to discuss things. While Dan Gluck was with the ACLU, he did have litigation and he was very successful. One example I cite is that while he was the ACLU attorney, Hawaii inmates could not get married. Don't ask me why, but Dan Gluck and the ACLU took that on in federal court, and a successful litigator doesn't only just try trials, but wins with settlements, and they got a settlement right away. So I think that's a indicia of a very successful litigator. Many people can try trials, but they don't always win. They don't always get a settlement. So I am in very strong support of him. And I urge your vote for him.
Thank you very much. Next is Susan de Guzman. Good morning.
Good morning. So should I just go ahead?
Yes, please.
Okay. I submitted written testimony, but I'd just like to comment about the perception or concern that Dan lacks trial experience. Now, I was the chair of the Ethics Commission and served with Dan for about 3-4 years. But I wonder, what does trial experience really mean? Does it mean that the nominee must have actually tried a case or a certain number of cases to a verdict to qualify as trial experience? attorneys who practice civil litigation would be hard-pressed to demonstrate trial experience if it were so narrowly defined. I submit that trial experience is more than just actually spending time in court. Dan, along with his fellow staff attorneys, provides 1,000 or more specific, informal ethics advice each year, which requires application of the relevant law to a specific situation or set of facts, much like a trial attorney and even a trial judge. Dan and other staff attorneys also work towards bringing a case to an amicable conclusion by way of settlement, which requires strong mediation skills, again, much like a trial attorney or judge. When settlement attempts fail, a contested case hearing is needed. Dan and the staff split assignments by either prosecuting or acting as advisory counsel to the commission members. A contested case hearing is like a bench trial. As such, Dan gains trial experience in a contested hearing context. But like other civil trials, contested cases are rare because most cases settle. When individuals seeking advice request a formal opinion, Dan, for example, will gather the relevant facts, analyze the law, research applicable case law, including prior commission rulings, and craft an opinion for the commission's consideration, much like a lead appellate judge would do, and circulate the recommended disposition to other judges on the panel. So for the past 5 years as executive director of the commission.
Thank you very much. The 2 minutes is over. Thank you. Next is Ivan Louis Kwan. There you are. Good morning.
Good morning. Hello, Chair Rhodes, Vice Chair Keo Kalole, and members of the committee. My name is Ivan Louis Kwan. I have submitted written testimony. In addition to my written testimony, I would like to see a few other things. As a Native Hawaiian, it's very clear to me that Native Hawaiians don't speak with one voice. There are many Native Hawaiian organizations and even different points of view within the same Native Hawaiian organization. We know who they are: the Shaw, Sovereign Council of the Hawaiian Homestead Associations, OHA, Native Hawaiian Chamber of Commerce, the Royal Trust, Native Hawaiian Civic Clubs, Council of Traditional Native Hawaiian Healers, and many others. So as a Native Hawaiian and as an attorney, I speak for myself. And for me, the points which I made in my written testimony are very important. The first point is that this nominee, Mr. Gluck, is highly qualified to serve as a judge on the ICA. Let me also say that I don't know Mr. Gluck, and no one has asked me to testify on his behalf. The main reason I'm testifying is because of the second point which I made in my written testimony, which is that I feel really strongly that the quality of life in Hawaii depends on qualified judges and a strong judiciary with good integrity. As I said, I feel strongly that qualified judges are critical to the delivery of justice based on fairness and to maintenance of a healthy community in Hawaii. When I graduated from law school 50 years ago, I served as my first job out of law school as a law clerk to C.J. Richardson. The most important principle which the C.J. taught his law clerks was the necessity to be fair. He used to say, what is a fair result in this case? We need to treat everybody fairly. So the implicit lesson is that even though we Native Hawaiians are committed to uplifting the lahui, we should be equally committed to treating everyone, all people, with fairness and with aloha. The second point I'd like to make is that I did not make in my written testimony is that the number of cases which a judge or a lawyer is associated
I'm sorry,
with.
Mr. Louis Kwan, your time is up. Thank you very much.
Thank you.
Next up is Zachary Alexander McNish.
Good morning, Chair, Vice Chair, and members of the committee. I've known Dan since 2006 when we were law clerks together. I believe that Dan is extremely well qualified for this position. I think he has a breadth of legal experience, which is something that we should want in our Intermediate Court of Appeals judges. And I think that Dan is one of the fairest people I know. I'm confident that he'll treat everyone fairly without bias. And he's just a tremendous listener and has a great judicial temperament. And I'll stand on my written testimony.
Okay, thank you. Next up is William Mowat.
Mowat, yes. Hi. Oh, no, thank you. Yeah, I stand on my written testimony in support of Dan's nomination. I just might add that I've known him for 25 years. He's an inspiration to me, and I cannot overstate my support for his nomination. Thank you.
Thank you. Next is Lois Perrin. Good morning.
Hi, am I on?
Yes.
I am. Hi, nice to see you. I submitted written testimony as well. I served as the ACLU legal director and of counsel from 2004 until 2016. And I had the opportunity to work with Mr. Gluck daily for almost 8 years. And I did submit written testimony, but I wanted to focus on a couple of different things. I mean, the first thing is that Dan Gluck loves the law. He absolutely devours the law. I see him and I've seen him reading opinions and just trying to understand every facet, every argument, every this, and to really get a handle on that. And I think that's so important for somebody that's going to be appointed, potentially to an appellate court position. The second is that Dan is one of the most fair people that I know. He is even-headed. He is able to mediate and to go through disputes. And he's just a terrific person to be around. And the third is that he has spent his life dedicated to social justice, beginning back at Harvard Law School when he started with the Legal Aid Society there. And he has continued doing that even today, doing pro bono cases and so on and so forth, just to bring social justice to those who care. I think that he will be an amazing, amazing person on the bench. And I do very much hope that he is confirmed. Thank you.
Thank you. Members, let's go ahead and break there and ask, I'll open it up for questions for these first 10 testifiers. Members, any questions? I'll go ahead and start then. Mr. Louis Kwan, are you still here? Yes.
Yes, I am.
I was actually curious what your second point was, if you can remember where you left off and just summarize your second point for us.
Yes, thank you so much for that, Chair Rhodes. What I wanted to say is that the number of cases which a judge or a lawyer is associated with is not in and of itself a good measure of qualification. On this issue, quantification is not as important as qualification. For example, the number of cases which the Supreme Court works on is a very small number, but they are very important and complex cases. By contrast, the district court works on a very large number of cases because of the nature of the district court's subject matter jurisdiction. But clearly, that does not mean that district court judges are better qualified than Supreme Court justices. The same applies to lawyers. In my law firm this year, litigation lawyers have worked on 3 major litigation cases, 3 different litigation teams, each team with 3 or 4 litigation attorneys. And those cases are very difficult and complex. And so those lawyers work on relatively few cases, but they're highly qualified. So my point is that quantification should not be by itself the measurement of qualification. Thank you for that, Chair Rhodes.
Thank you very much. Members, any other questions for this batch of witness testifiers? Okay, I have one other one for Lois Perrin. Yeah, you're still here. So, can you describe some of the litigation and trial work that you did together with Mr. Gluck?
Oh, wow. Okay. As far as trial work, we never actually went to trial. As far as litigation work, and also you have to remember at the ACLU, a lot of our cases, the intent is not to go to trial and is to settle cases in order to benefit more people. So Dan and I started together, back in 2007. We brought a case about mandatory teacher drug testing, which ultimately landed in a settlement. We brought multiple cases about homelessness. One of which was the McKinney-Ventnor Act, and it was ensuring that children who were homeless and had no address would have the ability to get to school and to have free lunches and other things. That has actually served thousands of people, and to my knowledge, that McKinney-Ventnor notice is being given to people every day. We also brought a Title IX suit in the Baldwin case over in Maui, where quite literally the boys had a beautiful stadium with locker rooms and boosters and so on and so forth. And the girls were sent across the street to play with rocks and sticks. And we were able to get a preliminary injunction from Judge Ezra, and they now have an appropriate facility.
Do you consider these cases run-of-the-mill cases?
No, they're actually very difficult. So at the
why are they difficult?
Well, I think they're difficult because for a number of reasons. One, you're looking at people who have been typically discriminated against. And so at the ACLU, we're looking at who has been discriminated against by the government. And so for that, you're taking cases and you're really trying to battle the government for certain things, and not everybody is behind you all of the time. Not everybody agrees with our positions. Not everybody agrees with what we're trying to do. It's also important to note that most these clients, they don't actually, for the most part, get money damages. They're doing it because it's the right thing to do in order to change the law, to move the pendulum just a little bit more towards civil rights.
All right.
So, I'm sorry.
Thank you very much. Appreciate it.
Okay. You're welcome.
Members, any other questions for these 10 witnesses? Testifiers.
I want to follow up.
Senator Favela, go ahead.
Yeah, with what she was saying. I understand the complexity and the great things that he did as an attorney and going forward. But part of being in that department and being attorney for the civil rights, isn't that part of his job to select and try to accomplish the task of hand? That's his position. So I'm hearing a lot of, about not him having experience, but the complexity of his cases and stuff like that. But then he never seen really too much in a courtroom because he settled it before going into the courtroom. But, we're not, I heard a lot of previous testifiers, and it's kind of confusing because we're bringing up, Native Hawaiians, we're bringing up not having experience and all of that. The complexity of this position that's going forward has nothing to do only just with the experience and about being Native Hawaiian. But you just said it earlier, right? That you ain't go and fight for gender equality because the girls was across the street playing with sticks. Wow, that's the reason why a lot of people is talking about this one. Because we have no gender equality in the higher courts. Because they're around playing with law books in the law clerk's office because they cannot get in the higher courts. Because people that, nothing to do it against him as a candidate, but every time when it comes to women and equality for women, it always numbers. So I give you guys an example. If none of them was men, all was women, and the governor had to choose for just women, on the numbers that we see now, who you think the governor would choose? When it comes to women now, I'm just talking about women. When it comes to women, yeah, they always look for the highest accomplishments, numbers, experience. But when it comes to men, we make excuses that they never have to have this because they're a good person or I work with them a long time. That has nothing to do with that. I'm a Native Hawaiian. That has nothing to do with that. Going forward, not only being a Native Hawaiian, but just equality. This is what a lot of people are saying. I'm not hearing it by these testifiers. Maybe we'll hear it later. But that's the reason why the community has been saying certain things in the media and in the Facebook and all these places. It's just gender equality. You hit it on the head. You said you never like the girls playing with sticks, but the boys had beautiful gyms. Well, it's the same thing that we want for these Native women, right? Or just women in general. We want them to have the just equal opportunity to rise up in the law and into judges in different positions, not because of their numbers. And you notice as a woman, you guys all work harder, 10 times harder than men, and some of you guys don't get equal pay and don't get equal recognition. So that's a topic that a lot of people have been sharing with me. So I have no idea about, the Native Hawaiian part and how good the guy is. I don't know him personally, but I'm just saying, if we're going to go forward, we need to be fair right across the board in equal rights for everyone. That's what you just said. So if we're being equal, then we should look at these women or the other men that has higher numbers. That's what the community is concerned about. Not about how good of a guy he is in court and how he get along with his clients. Is what going forward is going to be the best thing for Hawaii's people going forward in this higher court. That's it. Thank you, Chair.
Okay, thank you. Members, any other questions?
Sorry, was that a question? Am I allowed to respond to that? I thought it was a question.
There wasn't really a question, so it's okay. Members, any other questions?
May I just make 2 points? Because I do think that there were 2 points. I mean, the first is Senator Rhodes.
So I don't. Hang on a second, Senator Favela. Did you have a question for her, or did you just want to make that statement?
It was just a statement because she brought up stuff.
Okay, so that's okay. We'll leave it there. Any other questions? Okay, if not, let's go ahead and go on.
Yeah, Chair.
Oh, I'm sorry. Senator Lee, go ahead.
Thanks. I was just curious what Ms. Perrin's response was, because it seems like this is going to be the crux, I think, of much of the testimony to come.
Thank you. I think the first point that I have is that Senator Rhodes, you asked me specifically about, I am coming through, right? I'm sorry, I'm a bit of a lighted on this. You asked me specifically about the trial experience that I had with Mr. Gluck at the ACLU. And I gave some stories about what Dan and I had done together. I did not, however, talk about all of the different immigration hearings he did while he was at the ACLU, where he had multiple evidentiary hearings. I have not talked about all of the things that he has done at the Ethics Commission, where he had multiple evidentiary hearings, because I was not at that time working with him. He does, in fact, have that experience. The second thing is that, as far as gender equality, gender equality is about being equal and being fairly considered. So to be fairly considered, there were 5 nominees. Those 5 nominees were actually considered and they were selected. Dan has been appointed because, in the governor's esteemed opinion, he is the most qualified. And I can say that he is, in my opinion, very qualified. He will absolutely do everything he can to secure and to defend gender equality, all fairness, because that is the person who he is. He will absolutely love the law and he will follow the law.
Okay, thank you. Members, any other questions for this group? If not, let's go ahead and move on to the next group. Thank you all for testifying. And like I said, you're welcome to stay around, and there may be more questions for you later, but this could last a while. So if you need to leave, we totally understand. Next up is Matthew Winter.
Good morning, committee. Thank you very much for allowing me to testify. Just by way of background, I'm a lawyer here in Honolulu. I have both civil experience and criminal law experience. I was a federal public defender for 12 years. Now I'm a partner at Davis Levin Livingston doing civil work. A lot of these people have testified that there's a big difference. When I was a public defender, I was trying cases all the time. I was in court every day. It's different being a civil attorney, and it's something that I expected. But frankly, it's something that I still think is pushing the law forward. And I think that I'm doing my job at handling cases, appearing in court, and doing things as good, if not better, than when I was a public defender. What I want to tell you about Dan is I've known him for about 12 years, and I'm someone that's actually sat in the hot seat with him. I've done cases where I was co-counsel with Dan. I've seen Dan argue in federal court. I've seen him argue complex motions on qualified immunity. I've seen him take depositions. I've seen him do judicial settlement conferences in cases. I've seen him do all aspects of a case except for a jury trial. But I can tell you, in the civil realm, those are important and incredibly important steps to the case. I've seen Dan write the most brilliant motions and argue in front of judges incredibly complex issues. What I want to tell you is when you have a candidate like this, someone who has civil litigation background with the ACLU doing civil rights, and is the state ethics commissioner, you're not going to find someone that's tried 50 criminal cases. You're going to find someone hopefully like Dan. And what I do is I want to point out someone like my friend Todd Edmonds, who's an incredibly gifted attorney and great choice for the Supreme Court. When he was a public defender and when he was doing criminal law, he had hundreds of cases. When he did civil law, he had very few cases that went to trial. It's just a difference in the practice. You have someone that's very qualified, and you have someone that you should strongly consider for this position. Thank you very much.
Thank you. Next up is Paige Ogata.
Good morning, Chair and Vice Chair and members of the committee. I've submitted written testimony, and I do not intend to rehash that written testimony. I am here in my individual capacity as a female attorney here on Oahu. And I don't say that I represent everyone's opinion, but I do know from speaking to people that others do feel the same way I do. I have no reason to doubt that Mr. Gluck is intelligent and hardworking and loves the law. I have no reason to doubt that he's a good attorney. But what I am saying is that I do not believe that he was the most qualified person on that list. I'm not saying he's not qualified at all. I'm just saying that there were others who are more qualified. And I say that as a female because when I was in law school, I sat in a Senate hearing room and listened as member after member after member of the bar came forward to lambast Judge Leonard when she was up for the position of Chief Justice of the Supreme Court. She was told over and over again how she was unqualified despite being a judge at the ICA. And this is nothing against Chief Justice Rechtenwald. He's doing a wonderful job and he is a wonderful person. But the fact remains that as a female, we all as attorneys seem to have to do a little bit more to be considered qualified than a man. And as much as I also have practiced criminal and civil law, I've done both criminal and civil trials. I am currently prepping for a federal trial in civil court that's going to be going in a week. But I just wanted to put my opinion forward that as many people have pointed out, I'm a majority. I am a white and Asian female attorney. However, I'm raising Hawaiian children, and I would like to see more people who look like my children be reflected on the bench. And I'm happy to answer any questions anyone has.
Thank you very much. Next up is Dr. Jamaica H. Osorio.
Hi, Chair, not present.
He was in opposition, is in opposition. Next is Larry Geller. Yes, there you are. You're muted. There you go. Good morning.
Good morning, Chair, Vice Chair, members of the committee. I did submit written testimony, which I'll stand on, but I do want to say that I'm not testifying. The testimony was in opposition, but I do not oppose Dan Gluck in the same way, that I find in fault with him. Any of the recommendations that were made to the governor, I think would make very suitable justices on the ICA. But as President Biden has demonstrated on a national level, it's possible to make appointments that take into account competence, integrity, experience, and diversity. The community has written, it's been in the newspaper, you've read it. Apparently it's been on Facebook. The concern here is the diversity aspect. We have another candidate who's Filipino, and there are other candidates who are women. Any of them, I think, would make good appointments. I urge the committee to take this into consideration. If any of the candidates came before the committee as part of a governor's recommendation, the testimony would be overwhelmingly in favor of the candidate, as is the testimony in favor of Dan Glick. I urge the committee to send this recommendation back to the governor and return the nomination to him for a second try, and to establish that for this nomination and for future nominations, he should be taking into account the diversity represented by the Hawaiian population, the Hawaii population, actually, to be completely inclusive. Thank you.
Thank you very much. Next up is Bob Toyofuku. Good morning.
Good morning, Mr. Chairman and Senators. I am Bob Toyofuku, and I'm testifying in support of Daniel Gluck as an associate judge on the ICA. I have known Dan for over 15 years, and I feel that he is eminently qualified to be confirmed as a judge on the ICA. His credentials and his work as an attorney for the ACLU, and especially with the State Ethics Commission, are unique and will bring a valuable perspective to the ICA, especially during these times when ethics is a major concern with the public. Mr. Chairman and Senators, with the utmost respect for all of you, because I have been involved with the legislative process for almost 40 years and testified many times on confirmations, and because of the public attention on the issues of representation and diversity, I feel compelled to take a brief moment to make some comments. Although these are important issues to be generally discussed, I feel that this is not the proper venue to have these issues be determinative of whether any nominee for the judiciary is qualified when the Senate is considering to confirm or not. I assume that all of the attorneys on the list are qualified, but I also do not feel that this process should be such that a person should be confirmed or not because others on the list who are not nominated are deemed to be better. It's just my opinion, that the appointment is really the prerogative of the governor. Lastly, as to litigation experience, as an example, I do know that ICA Judge Harry Tanaka did not have litigation experience, but was regarded by many as an excellent appellate judge. I have personal knowledge of this because Harry was my father-in-law. Thank you for allowing me the time to testify and to support Mr. Gluck for his ICA position.
Thank you. Next up is Nicholas Kaprowski.
Good morning. Good morning, Senators. My name is Nick Kaprowski. I testify strongly in support of the confirmation of Dan Gluck. I've known Dan for 16 years. I am a lawyer, a civil litigator here in Honolulu. I've been co-counsel with Dan when he was at the ACLU, and I was at my private law firm. So I've seen his litigation skills firsthand, and I know he has the skill and the experience to fulfill this position. The ACLU takes on hard cases. It takes on unpopular cases. These are not the cases that the lawyer of the average skill or of the average amount of courage would take on. It takes some more both to take those types of cases on. So in light of that, I will rest the remainder of my comments. I will rely on my written submission. Thank you.
Thank you very much. Next is Dawn Sperlin.
Not present, Senator.
Okay, she was in support. Kenneth Walchuk. You're still muted.
It's Walczak.
Walczak, I'm sorry.
Yep.
Go ahead.
Good morning. I'm here to strongly voice my support for Mr. Gluck. I've known him for 20 some years now. And like others who have spoken, I think quite eloquently about his qualifications, I have sat side by side with Mr. Gluck and litigated cases all the way to the verge of trial. As Ms. Perrin pointed out earlier, there are ACLU cases that reach the courthouse steps and then settle and result in a favorable outcome for the ACLU and its clients. I was co-counsel with one of those. I am a litigator and a former civil rights attorney in San Francisco, and Dan and I worked at every stage of that case, from drafting the complaint to doing press release, to doing interviews, to interviewing inmates in prisons on both the mainland and in Hawaii, to conducting depositions. And so I have seen Dan's acumen as a trial attorney firsthand, and I think he's a fantastic litigator with every bit as much qualification as he needs for this position. I also think, as so many others have said very eloquently, he has the ideal demeanor for a jurist on the bench. With that, I will rest on my written testimony, and I would gladly answer any questions.
Thank you. Next up is Kilikina Moani Mahi. Yes, good morning.
Good morning. Aloha mai kako. Mahalo for the opportunity. I'm here to testify in strong support for Dan Gluck. I've known him personally for almost 15 years, and I've known him to be one of the most hardworking and dedicated public servants that I've been able to come across in my time in Hawaii. And I think he would serve our people and our state well, given his commitment to justice and equity. And I will stand on my written testimony. Mahalo.
Thank you very much. Next is Deidre Marie Iha. I'm sorry, that's wrong. Leanne Abesugawa. I apologize, Lee.
Hello, Chair, Vice
Good
Chair
morning.
of the committee.
Sorry.
Sorry, my dog is barking. My name is Leanne Abesugawa, and I'm here in strong support of Dan Gluck. I did submit my written testimony, and I will stand on that testimony. I have known Dan for 18 years, and he has been an exceptional citizen and social justice advocate, and he is one of the best people that I know. So thank you very much for allowing me to be here to support Dan's nomination.
Thank you very much. Okay, members, that's another 10 testifiers. Let's go ahead and ask some questions if anyone has questions for anybody who's testified already. Let's see, I think I had one for for Nicholas Kaprovsky. Sorry, I think I still butchered your name, even though I heard it once. Yeah, so in these cases you talked about with the civil rights cases you worked on with Mr. Gluck as co-counsel, I mean, what's the difference between an easy case and a hard case? And if a hard case is a 10, how complicated is what you and Mr. Gluck worked on?
A 10, and I'll tell you why. There were a couple facets of that. One is because we were basing it. This was a homeless rights case, and we were basing it on a Ninth Circuit precedent, which kind of created a very narrow ruling that said you can't take homeless people's property when you're doing these homeless sweeps and just trash it, and then it created sort of a broad exception. So legally speaking, we were kind of going on uncharted ground and had to, basically find precedent from all over the country to support what we were doing, the facts here. And in terms of the other aspect, which is factually why it was hard, we had something like 25 homeless clients. And Dan's responsibility was developing those clients and fostering and getting them to be clients and getting their testimony. And he literally went down to homeless camps almost every single day and would walk around and search to see where our clients were, because a lot of them didn't have cell phones. We couldn't find them. Most of them, or not most of them, but many of them were Micronesians, and there were English language barriers. And it was really kind of a lawyer pounding the pavement to develop this case. And frankly, I don't think I've ever seen that in a lawyer I've worked with. Certainly not in the business litigation context that there was one client we were trying to find where Dan was had to wait outside the district courthouse for that person because he saw that the person had to go to a hearing or something, because we needed them to finalize their testimony. So it was a very challenging case, and he handled it expertly.
Okay, thank you very much. Members, any other questions? Okay, we'll go ahead and move on. Let's see. Next up is Deidre Marie Iha. Sorry to jump the gun before. Good morning.
Good morning. Thank you, Senator, Chair, members of the committee. Thank you for the opportunity to testify. I am testifying in strong support of Daniel Gluck's nomination to the Intermediate Court of Appeals. I've worked in the state appellate courts for more than 17 years and have personally handled hundreds of appeals. I would be thrilled to see Dan on our appellate bench. He's incredibly smart. He's thorough. He has a very calm and measured temperament that will carefully consider the law. And I wanted to give one tiny anecdote to focus on his appellate experience and why I'm so sure that he would make a terrific addition to the ICA. A few years ago, I helped Dan to do a moot court for an appellate pro bono case that he did in front of the Hawaii Supreme Court. And a couple of us did a moot court for him. We helped him prep, and I watched the argument that he did in front of the Hawaii Supreme Court. It was, in all honesty, one of the finest arguments I've ever seen done in front of the Hawaii Supreme Court. And the reason why that means so much to me is he had a complete grasp of an enormous record on appeal, understood how that record and the facts interact with the appellate standards of review, which is the rules of the road for every single appellate court proceeding. And he handled himself incredibly thorough preparation, ability to respond, exactly the level of engagement with the record that I would want to see for any of my clients in any of my cases on appeal. Thank you very much for the opportunity to testify, and I also did submit written testimony. Thank you, Senator.
Thank you. Next up is Marty Townsend for the Sierra Club. I'm sorry, I did it again. I apologize, Marty. It's actually Jill Leilani Nunokawa.
No problem.
Good morning.
Good morning. So much to say, so little time to talk about justice like water and righteousness like a mighty stream. How do you condense colonization to 2 minutes? You don't. I encourage everyone to read my testimony. There's a lot in there about how we are Hawaii and how we've reached this moment in time where power, control, and dominion can circumvent procedure, spin merit, and turn this confirmation hearing into a popularity contest with impunity, entitlement, and confidence in the end result. Like our history with annexation, it all feels so orchestrated, unjust, and against the very tenets that built our fractured society. The standard of review is not niceties or liberalism. We are here to ensure that the public trust is not further eroded by the actions of a few, that there's still some semblance of checks, balances, and true accountability in the selection of appellate judges. Senators, it's gut check time. We are Hawaii, with our history of colonization, Big Five dominance, structural bias, and how it controls through the ongoing tendrils of power politics. We have reached the crossroads of humanity, and we have tough choices to make. Retired Justice Jim Duffy once told the graduating class of the Richardson School of Law, lawyers are healers. We are here to heal our community, not harm it. He is spot on. It is this statement we find the framework by which we make decisions. Healing, not harming our communities. Nepotism is harmful. It played a significant role in this nominee selection by the governor. Read my testimony. To completely disregard legal standards of procedure and substance sets the tone to dismantle all respect and belief in the justice system by the public. It's about the process that we preach. Fairness and kuleana call upon each to make your decision in the context of your community, the framework of healing, and the knowledge of the historic colonization and its ongoing insidious and crippling grip on truth, justice, and equality. The vote is yes for transparency, integrity, and accountability. The vote is no for nepotism, entitlement, and this nominee. Thank you.
Thank you. Next up is Marty Townsend for the Sierra Club.
Thank you very much. Before I attempt to summarize the Sierra Club's 8 pages of testimony, I want to personally thank Dan for helping me and many others in my similar position to root out government abuse. Dan helped to make our jobs less dangerous and humiliating, and we are forever grateful to him for that. And I think that's part of the reason why this testimony is so hard for me to deliver. It is extremely unfair that Governor Ige has put Dan, and frankly all of us, in this awful, awkward position. I feel particularly bad for Dan because I see so much of myself in him. I see us both as fierce do-gooders, working to advance the cause of justice, smart and ambitious and relatively recent white settlers to Hawaii. One key difference between us is I do not see myself as a savior of the underdogs, as the nominee has been described, but rather as an ally for systemic change to liberate all of us from oppression. And being a good ally in the fight for justice means not using my white privilege to block the advancement of those who have persevered despite the unjust system to successfully serve the community that raised them. Our testimony argues that our society is more just when the governed and the governing see themselves in each other. What much of the testimony submitted today by the not elite is trying to tell you is that nearly half of the governed in Hawaii do not see themselves in our justice system. This is a serious problem for the functioning of our democracy. Every time we rationalize favoring a white male over equally skilled non-white women, we are perpetuating an anti-democratic racist system. And with each confirmation, we seem to be slipping farther from the society we are striving for. Confirming the least qualified and only white male candidate from a list to a bench that is already dominated by white men only serves to weaken our representative democracy and cement the anti-democratic influence of white male supremacy in Hawaii. But we can flip that trend starting today by rejecting GM1 and directing the governor to nominate the most experienced, most rooted, most representative candidate on the list to the vacancy on the Intermediate Court of Appeals. And I'm open to answer any questions. Thank you very much.
Thank you. Next up is Crystal Glendon.
Aloha. Aloha. I'm sorry, I can't start my video and I'd really like to.
Okay, go ahead. Try to figure it out. Oh, there you go.
Thank you. Aloha, everyone. My name is Crystal Glendon and I oppose Daniel Gluck's confirmation. I'd like to tell you a little bit about my experience as a Native Hawaiian female attorney in this land. I recently handled a complex civil litigation case where my partner and I were the only 2 women lead counsel in a room full of men from 2 different Honolulu law firms and mainland coverage counsel. And the pushback and gaslighting that we got was subtle, sometimes overt, but it was definitely there. I have been practicing law as a trial litigator for the past 17 years, and that was an eye-opening experience for me, seeing firsthand how the lack of gender diversity and representation unfolded. I grew up in this practice in criminal courts. Being a public defender and a government lawyer, I've always been surrounded by at least 50% women or more. And at least for me, and I know a lot of other women in the same boat, this was a pathway for us to be litigators and to also have families. The men in criminal practice have rarely, if ever, made a big deal about me being a woman practicing law alongside them. And in fact, I'm heading to district court right after this for a prelim where I am the only woman at counsel table. The sheer number and presence of women in the criminal practice is why our gender is a non-issue. Representation and presence, they both matter. Do we need more women judges? Absolutely. You want women to apply for judge? Criminal government practice is where a lot of women come from. To not consider their trial or appellate experience simply because criminal practitioners are bound to get it. It is really a disservice to the years of hard work put into developing the skills that I believe are necessary to be an effective jurist. And it's another way to keep qualified women off the bench and out of the judiciary. Do I believe you need actual, real trial and appellate advocacy skills to be an effective jurist? As a criminal and civil practitioner, absolutely. I've appeared before dozens of judges across the state for the last 17 years. And to me, the best jurists at all levels of the courts are the ones with the most trial and courtroom experience. Who are appellate judges judging? Trial judges and litigators. And how do you do that job effectively? By having that experience yourself. And lastly, I am Hawaiian and I come from a long legacy of proud Hawaiians.
Next is Shauna Logan Kukila for Hawaii County Committee on the Status of Women.
Aloha, thank you, Chair. On behalf of myself and my ohana and my community, I humbly submit this testimony regarding the governor nomination of a new judge. It is with sincere gratitude and spirit of aloha that I pen these words today. Mahalo to the State Senate Judicial Committee for this opportunity. Today, I neither support or oppose any judge, but I come with my mana'o and a request. First, my story. In 2017, I was in need of legal and advocacy support from the ACLU and the Civil Rights Commission to defend my rights as a mother and to defend the rights of my disabled child. However, I was turned down due to their overload of cases. I have the letter. At the same time, a Japanese tourist was in the news getting legal representation and advocacy by these same organizations. This is why I'm here today. As a woman with deep roots in the Aina of Hawaii, I have seen the devastation and felt it of my people within the court system here in Hawaii. So I must speak for the past, present, and the future of my genealogy, and for the preservation of my ohana, my people, and for the pono of all people who call Hawaii home. Oftentimes it is we who suffer from an unjust legal system, particularly Hawaiian women. Therefore, to our leaders, I humbly ask for your kukua as we move forward and together in Lokahi. For too long, injustice has been committed against the people of this land of aloha, and this must change. We see every day how this injustice turns to a legacy of mistrust, particularly between the people of Hawaii and the state of Hawaii court system. By appointing judges, our leaders hold a sacred kuleana to the most vulnerable and endangered of people in our own homeland. It is for this reason that the committee and the Senate at large remain vigilant in placing judicial leadership into the hands of those who are dedicated to the solemn words of King Kauikeaole in 1843, Ua mau ke ea o ka aina I ka pono. This is the highest standard of justice, and that the courts reflect his vision. Mahalo.
Thank you very much. Next up is Liza Ryan Gill.
Aloha. Thank you very much, Chair Rhodes and of the committee. My name is Liza Ryan Gill, and I am the co-coordinator of the Hawaii Coalition for Immigrant Rights here in Hawaii. And we are testifying in support of Mr. Gluck's nomination, though we would love to see another candidate. This is the nominee that the governor has put forward, and knowing Dan's experience, we also want to say that, you know, though we would love to see more representation and foreign-born people on the bench, we know that Dan has been committed to representing immigration issues and asylee. We know that his experience will lead him to be a compassionate and empathetic judge and look at foreign-born people in the same way as natural-born. So thank you very much, and we stand in strong support.
Thank you. Next up is Tricia Nakamura.
Not present, Senator.
Not present. In support. Next is Candace Fujikane.
Aloha mai kako. My name is Candace Fujikane, and I'm an English professor at the University of Hawaii. I'm here to give testimony against the appointment of Daniel Gluck to the ICA. I'm actually speaking here for two reasons. I asked the Senate to reject Mr. Gluck's nomination, and I'm also speaking directly to Mr. Gluck himself, asking him to step down and withdraw his candidacy. Mr. Gluck, you are here in a historic moment. I ask you to treat your nomination as you would a court case, and your actions will convey to us whether you are someone who can truly determine a just course of action. I want to point out that most of the people who have spoken in support of your nomination are white or Japanese, and that lack of diversity illustrates systemic white and Japanese privilege in Hawaii. And those who support Gluck, who see no problem with his being appointed over 3 Kanaka Maoli women who are more qualified than he is. So consider this: there are no Hawaiian, Filipino, Pacific Islander, or Black judges at the Hawaii Supreme Court or Intermediate Court of Appeals. It's been 20 years since there's been a Hawaiian justice on the Supreme Court, and 30 years since a Hawaiian nominee has been appointed to the ICA. Because Kanaka Maoli are not represented in the judiciary, we see now Hawaii's lands and waters suffering from decisions that fail to respect the specificities of Hawaii's traditions of stewardship. Judge Richardson was one who achieved such justice regarding the unique conditions in Hawaii, including protection of public trust lands and waters. And this was because of his experience as a Kanaka Maoli judge. And the Kanaka Maoli women who have been have been nominated, have the potential to achieve that same greatness. So I ask you, Mr. Gluck, as a white settler on Kanaka Maoli lands, to take that step that will illustrate what true justice is. I ask you to step down. Thank you.
Okay, let's see. Hang on just a second. Next up is D. Kapua Sproat.
Aloha Senators, and mahalo for this opportunity. Oops, can you hear me?
Yep, please.
Okay. All right. Aloha Senators, and mahalo for this opportunity, given how important this is for the future of our judiciary and truly all of Hawaii. I submitted written testimony in opposition, and I now highlight 3 issues. First, I'll acknowledge how difficult the situation is. I've been a practicing attorney and a member of the Hawaii Bar for more than 20 years, and I have never opposed a judicial nominee. But I am here today because this is one of those moments in history that people will look back on to see whether they're a part of the solution or the problem. Second, I join in the chorus of opposition based on the nominee's lack of professional and lived experience in Hawaii, which is all the more stark when compared to others on the shortlist. Legal practice experience matters because the ICA is about volume, and judges need to understand how the rulings will work in practice. Makahana ka'ike. The knowing is in the doing. Lived experience also matters because our laws reflect Hawaii's unique society and culture. C.J. Richardson, our only Native Hawaiian CJ since 1959, explained that our system of laws was built on our indigenous culture. After the illegal overthrow, judges during the territory ignored that, but C.J. returned control of interpreting the laws to those with, quote, deep roots and profound love for Hawaii. And he infused Hawaiian culture and value into our laws. You may hear criticisms of his jurisprudence as being provincial, but I call it culturally grounded. And it's why we have public beaches, flowing streams, rights to practice our living indigenous culture, and more. This is not some carbon copy of continent culture. My third and final point relates to that diversity is also an essential qualification for judicial appointments, and the lack of balanced representation in our appellate courts is a travesty of justice. This goes beyond this nominee. It's a systemic issue that we need you, our senators, to address now. You have an important and specific role to review this nomination, and I'm almost done.
Thank you very much. Next up is David Koila Copper.
Hi, thank you. Yes, my name is David Copper. I am a practicing civil litigator. I'm also the Director of Litigation of the Native Hawaiian Legal Corporation. Myself and NHLC strongly oppose this nomination. You know, the ICA really is incredibly important to our judicial system because these are the judges who review the decisions of the trial court judges. They make policy decisions and they make judgment calls that affect people's rights, their interests, and their freedoms they're often the last chance for a party in the court system. All of these factors requires nominees with experience managing high caseloads, experience in multiple areas of the law, and if available, actual judicial experience, and the bar should not be lowered for such a prestigious position. This appointment also sends the wrong message, right? That connections or pedigree can mean more than merit, and that our local children have no chance to become a judge purely based on their hard work and on their knowledge and success. And if you want to make a difference from the bench as an attorney, that you need to spend less time developing your legal skills and more time rubbing elbows and getting those connections, especially if you're a woman or a person of color. And regardless of the intent of this nomination, that is not the message we need to send. I understand that these decisions can't be based purely on numbers, right? That you want quality of experience and life experience, but there has to be a minimum if you're going to sit in judgment of other judges on a high court and make policy decisions. You need more court experience, in-court experience, than a second-year attorney, to be frank. Does not have to be the most numbers, but there has to be a bare minimum. And one last thing to say that, hey, merit and experience isn't everything when you have intangibles, when it's temperament or background, good fit. Please be aware of the history of this argument that is often used as a reason to pass over more successful, more qualified women and people of color in the workplace. So I ask you not to hang your hat on that argument. Thank you.
Thank you very much. Let's see. Okay, that's 10 more testifiers. Members, any questions for these last 10 or any of the earlier ones if they're still there and you want to ask them a question?
Can I ask a question?
Sure, Senator Kim.
Yes, Kapoor or Sproat. Hi, thank you so much for your testimony. Can you just expound more on high caseload? Because I've heard a number of testifiers talk about how, it's not the numbers and it's not how many cases. And, talk about a lot of administrative cases that were attended to by the nominee, and not being an attorney and not being really familiar with the day-to-day operations of the different levels of court. But can you expound a little bit more on that, please?
Sure, Senator. Thank you for that excellent question. And that's really at the heart of this issue, because we're hearing today from many of Dan's friends and I am the first to thank him for the incredible work that he's done in our community, that, he's a smart man and a good man, but our appellate courts and the Intermediate Court of Appeals in particular has a tremendous backload. So there are 6 appellate judges that review decisions in panels of 3. Their backload now is about 1,000 cases. So they have it's the workhorse court of our Hawaii courts. And that's why this is different than when looking at something like Elena Kagan. At the United States Supreme Court level, they have significantly more resources. It's just a very different kind of operation that what we're seeing at the ICA. And I think the emphasis that we need to make here is to look at practice experience. I have never, that's the focus, practice experience for me, and also lived experience here in Hawaii. Because you need to have, precisely as Mr. Copper said before me, a baseline of information to be able to, at the ICA level, you're looking at trial court judges, you're looking at attorneys, and you need to figure out, and some of these things you cannot just figure out by reading the transcript. You're gonna have to understand the evidentiary issues, the procedural issues, and that's why this is very important. And I would just point out, Senator, that that's why your folks' role today is so incredibly important. Mr. Toyofuku mentioned that there should be, this is advise and consent and we should defer to the nominations. But I want to point out in my written testimony that I detailed that the 1978 constitutional amendment specifically gave the Senate the role of balancing and looking for the best possible nominee. And that's why the comparison is relevant, that this is not, and that's why it needs to be had. So I'm not sure if I answered your question, but I'm happy to.
You did. Thank you. I appreciate that. And I just need to say this, that, it's not easy to come and oppose. I've been doing this for many, many, many years. And it's not easy to oppose a candidate, especially a candidate who's qualified. And I really, really want to thank all the women who's standing up for women. Finally, we're hearing whether or not this prevails or not, the fact that we're willing to stand up and we're willing to speak our minds and not be afraid of of the repercussions. And I think that all of you women of speaking in opposition have been so articulate. And I thank you folks.
Thank you, Senator. And
the men too. Thank you.
One more thing, if I may, in response to that. You know, you see a couple of us here today, but I have had more feedback and more discussion about this specific judicial nomination than I have had in my 20 years of practice. And yet many people are unwilling to come forward. They're afraid for personal reasons, for professional reasons, for political reasons, frankly. And so that's why you only see a few of us here today. It's very easy to stand up for your friend and talk about what a great person he is.
Yes,
so,
and you know, and we as legislators have a role, but so you as a public, you folks have a role too. So thank you for showing up today.
Mahalo.
Yes, Senator Ocasio, go ahead.
Yes, I have a few questions, but I was actually going to ask that same question to Mrs. Sproat, but also Ms. Sproat, can you answer, you can finish your last statement?
I'm sorry, you're breaking up.
Asking Ms. Sproat if she can finish her statement.
Oh, okay, go ahead. Yeah.
Thank you so much, Senator Ocasio. Yeah, my last point that I wanted to make was really just to emphasize the really important role of the Senate in this. And this is not advise and confer, that in this that during the 1978 Constitutional Convention, they specifically looked to you folks, because otherwise the judicial nomination process is largely just within the governor's office. This is the opportunity for public input. You folks are, you know, and so that's why you have a very special and important role. And that's why it's important and relevant for us to look at issues like lived experience and practice experience and how this list compares.
Thank you. I also have a question for Mrs. Townsend, if she's still available.
Please proceed.
In your...
She's here, right?
I'm here.
Ms.
Okay.
Townsend, yeah,
Okay.
in your testimony with the Sierra Club, you mentioned that Sierra Club is reckoning with its racist past and policies. Can you briefly expound on that, about practical lessons learned that may be relevant to this discussion?
Yes, thank you very much for that question, Senator Ocasio. It's been at least 10 years of an effort for the Sierra Club to address and try to approach being an anti-racist organization. And in the course of that time, we are learning skills and lessons. I think one of them is to embrace the discomfort. Once you recognize that we are operating in a racist system, being comfortable means you might actually be perpetuating that racism. And so being uncomfortable actually might be a good sign that you're actually addressing something. Maybe it's like, you know, the pain you feel when you're working out. I would also say that we were learning that, you know, white male supremacy is nearly invisible and nearly everywhere. It's in every aspect of our lives, and it's especially hard to be seen by the benefactors, right? People who benefit from white privilege have a hard time recognizing that the benefits they are enjoying are due to the privilege as opposed to their own rationalization of their hard work. They earned it. Also, so the way that we have, like the third main point I would make is that the way you address that invisibility is to focus on measurable outcomes, really focus in on the facts of the situation, because racism thrives in subjectivity. When you have to rationalize and justify a choice based on like intangibles and like sentimental justifications, he's such a nice guy, you know, there's just something about him. Her cases were not important, his cases are important. Those are examples of rationalizations. And those themselves, I think, should be a red flag and cause you to really confront the reason for your choice. Are you just trying to justify the outcome that you want? When you review things like statistics and trends, like in this situation where 71% of all of the judicial nominations over the last 8 years have been men of white or Japanese ancestry, when you look at those, then it helps to reveal the actual racist nature of the approach that we are taking. And once you're able to identify it objectively, then you are able to take the immediate steps necessary to remedy it. It's that moment where you realize you're in a hole, and so the next thing you do is stop digging. So yeah, I think the Senate has an opportunity to really reflect on its role in the trend. You know, it used to be when I was a child that our court did better reflect the governed, did better reflect the citizenry of Hawaii. And it's over the years, we have gotten farther and farther away from that. And if the Senate can take a step back and objectively assess that and see its role, then the next logical step then is to start making decisions that directly counter that. I think that might be the fourth lesson, is that you can't just be suddenly not racist and address and expect the system to not be racist, right? We are living in a racist system. The water that we are breathing as fish is polluted. And so even if we just stop as we are now and just keep going, the systems of oppression that are in place will continue and endure. And really, to be able to live in a just and equal society, we need to counter the racism. We need to clean the water that we are breathing as fish. And so that's why we at the Sierra Club, we just, every time an example of white male supremacy comes up, we stop what we're doing and we confront it, and we immediately take measures to address it. Thank you.
Thank you very much for that.
Members, any other questions? I did have one for Deidre Marie Iha, if you're still here.
I am, Senator.
So you've argued numerous times before the various appeals courts, including the Ninth Circuit Court of Appeals in the federal system, the Hawaii Supreme Court, and the ICA.
Yes.
But your testimony in support of Mr. Gluck, despite his relative lack of courtroom experience, is in his favor. Well, why does his relatively limited court experience not persuade you to oppose him?
Well, I think that attorneys of lots of different backgrounds and experiences can make great judges. And a great appellate judge is a different kind of judge than a great trial judge. And so what I want to see as an appellate practitioner, and why I am so sure that if offered this opportunity that Mr. Gluck will excel at it, is being able to quickly go through a massive record and understand what the dispositive legal issues are, the ones that really matter. Being able to root through the Intermediate Court of Appeals does indeed have an enormous backlog. They do almost all their cases with no courtroom at all. It's all on paper. So being able to root through all of that and figure it all out and apply the appellate standards of review. And when I mentioned, Senator, that one argument that I saw him do a couple years ago in a pro bono case that he was doing in front of the Hawaii Supreme Court, if you grasp the appellate standards of review, then that is literally everything to an appellate case. It's the rules of the road. It's the means by which the ICA operates. You add that to the rules of appellate procedure, and it's all there. So it's not that I think that a really great trial attorney could not also make a great judge. It's just that you can become a great judge with lots of different legal experience. And I think Dan has the skills and the temperament. Thank you, Senator.
Thank you. Members, any other questions for this group?
Chair Rhodes, I do actually have a question for Mrs. Glendon, if she's here.
Sure. Senator Koski, go ahead.
I'm here. Yeah.
Could you address this question? Should it not be our job as the Senate to question the governor's intrinsic bias in his selections when he picks women of color for lower courts, but not for the ICA?
I would absolutely, I'm trying to start my video again. It's saying that I'm not allowed to, but.
Yeah, if you can let her in, if that's the problem.
Thank you very much. Hi, I'm here. Okay. Yeah. Hi. To answer your question in terms of whether or not, you're absolutely right. I do see a lot more women on the lower benches. And to me, I mean, considering that the higher benches are going to be the ones that are looking at whether or not the trial courts got it right or got it wrong, or the litigators got it right or got it wrong. To not have women, especially a woman of color up there when we have 3 qualified applicants, to me, I mean, it's pretty telling that the governor is not selecting these people. And I mean, honestly, I don't know the answer, because as far as I'm concerned, the 3 nominees that are on this list are all qualified women who have been appearing before the appellate courts, who have not only the trial skills, but also have the actual lived practiced experience, as well as the experience of being Native Hawaiian and being from this community. The fact that they are not being selected is exactly the reason why I am here today testifying. And like Ms. Sproat said, This is the first time I've ever testified against a nominee in my 17 years of practice. I have definitely written support for other nominees, and I've written support in terms of, supporting their experiences. But ultimately, you have hit the nail on the head in terms of why aren't these women being selected? And my understanding is that they've been on the list previously. So for Mr. Gluck's nomination this is the first time that I've seen him make a list, because I pay attention to these things. And the fact that they were the 3 Hawaiian women who I believe have the most experience on that list and are the most qualified candidates for this particular job, the fact that they were overlooked is a question that I don't know the answer to, but I can tell you that's exactly the reason that I'm here testifying against Mr. Gluck's nomination.
Okay, members, any other questions for this group?
I have a question, and this is
go ahead.
Thank you. This is for Ms. Glendon or any of the practicing trial attorneys. I have asked the Senate attorney to validate the case stats that have been going around the internet to ensure that those are accurate. And the numbers that we got back were a little bit different, and I'm happy to share with the chair and the members since it did come from the Senate attorney, but they weren't very far off. And in terms of the percentages or orders of magnitude difference, they are, I think, functionally irrelevant. But the reason so the question is to any trial practitioner is that the Senate numbers, which like I said, are not that different from the ones that have been published all over the place in terms of cases where the nominees, represented a client in court. What they said was that anytime an attorney, any proceeding where an attorney was noted as the attorney of record counts as a case for those case stats that have been presented. And so multiple testifiers before have mentioned that Mr. Gluck represented clients in preliminary matters that were resolved as a result of them prevailing in those preliminary matters. Would those instances be included in those case counts? Mr. Winter.
No, I don't think they would. So when I did work with Dan at the ACLU, a lot of the cases that we handled were handled the way you'd expect the ACLU to handle it. First, to raise the issue with either the city, the legislature, the police department, the school districts, whoever was the target of that case or whoever the controversy involved, to raise the issue to see if the issue could be solved. And on a couple of occasions, I specifically did that with Dan, where we write a demand letter, we gather our evidence, we gather the players, and we go to that entity and say, look, here's a case or controversy that we've seen, and that you guys right now have a chance to fix it. In those situations, there wasn't a filed case. Where I would expect that you would see the stats are where there was a filed case. And what you have to think for this candidate is the number of cases that he's handled a controversy in this state that was not filed, from the Ethics Commission to the ACLU or from his other work. So yes, I've seen him on filed cases. I've sat with him at council table. I've seen him argue. Those will count. I've seen him also do demand letters. I've seen him work legislatively. I've seen him work through his lobbying efforts. Those probably didn't count because they weren't a filed case. The other thing to note is in my office, if one of my co-counsel files a case, there's a good chance that my name is on that case. The same goes especially for appellate departments of public defender offices. There might be multiple people on a case. I used to work in a public defender's office. If you search my caseload right now, if you search Matt Winter in any of the databases, you're going to see me on a lot of cases. And I might not have walked into court on those cases. Either one of the other public defenders did or one of my partners here did. So again, it's one of these things you need to look at the breadth of the person instead of the caseload. Here you have a breadth that's pretty remarkable for someone who could be on our ICA.
I got it. Yeah, thank you.
Were there other people you wanted to ask that? I'm sorry, Jared. I'm sorry. Senator Keel.
Would you like to expound on that? I just wanted to make sure we're understanding the numbers here. So okay. I think that's what I heard is when something is filed in court and an attorney is listed as the attorney of record, that's when the numbers kick in. And then you need to figure out the nuance from there to determine actually what their meaningful experience was. Is that fair to say, Ms. Glendon?
Well, I would say a little bit different, because when you're talking about public defender numbers, it's not oftentimes that you have, or even prosecutor numbers or any government attorneys, it's not often that we work in concert with other people. We don't collaborate on cases. A lot of times what happens is you are the individual attorney from start to finish. And so those numbers would actually be yours. It wouldn't be viewed in terms of augmenting your numbers because you've collaborated with other people or are co-counsel on it with other people, which I think might happen in the civil realm. So I would say this, that the numbers that we've seen regarding the candidates that are before, the ones that I've seen on all the charts in terms of the 3 nominees that I'm basically referencing, those are probably their actual numbers in terms of the cases that they were not only lead counsel on, but saw from beginning to end. And if we're talking about situations where there might not be, a case filed or whatnot, I mean, what that tells me is that the number of cases that they've actually handled are higher than the numbers that we're actually seeing. And the numbers that we are seeing are rather impressive. So that's what I would add to this conversation.
Okay, thank you. Thank you, Chair.
Thank you. Members, any other questions for this group? Okay, let's go ahead and take a 10-minute break. We'll come back at 12:30 and pick up the testifiers. So in recess for 10 minutes until 12:30. Welcome back, everybody, to the Judiciary Committee meeting on the Governor's message number 1, which is Daniel Gluck's nomination for the Intermediate Court of Appeals and for Leslie Maloyan's nomination on JC1 for the District Family Court for Oahu. Let's see, there were a couple of people who had signed up to testify and didn't manage to get through when their name came up. I think it was Heoili Osorio, or maybe that's Jamaica Osorio. I'm not sure which. If you're here, you're welcome to testify. No? Okay.
No, I'm here. I'm here.
Oh, there you are. Okay, go ahead.
Sorry about that. Aloha mai kako. I'm Dr. Jamaica Heoili Kaleni Osorio. You have my written testimony, so I'm just going to highlight a few things that were in there and not. Across Governor Ige's tenure, his prejudices are really clear. 71% of all of his appointments have been men, 71% have been white or Asian settlers. It's been 20 years since we've had a Kanaka on the Hawaii Supreme Court and 30 years for the ICA. So what I want to point out here is that this is not just the legacy of David Ige. This is the legacy of the provisional government and later the state of Hawaii since overthrowing and occupying our native government as a means to further disempower our people. And so we should face this particular issue with a sense of history. On that note, I want to point out the racist and sexist double standard of qualification, this idea that Gluck, a white man, would make a good judge because of his lack of experience when Native people and women of color have had to over-demonstrate our qualifications to be considered. This is actually the bias and the structural racism we are trying to address. So please, I ask you to pay very close attention to the reasoning of those who have written support, critically examine their analysis. The critical point remains, we need a court that has a demonstrated respect for our aina and our people. And the idea that Daniel Gluck cannot help who he is circumvents the important issue of representation and exclusion of Native Hawaiians and women of color from this court. It is true that Gluck cannot help that he is a white man, but he can, as a white man, take a critical look around him and see that he is not the appropriate choice and step down. And if he doesn't, you, senators, have the power to make an informed and intentional decision in our nomination confirmation process of how we put people into positions of power and leadership of influence. You have that specific power right now. So what Daniel Gluck can help or not is really irrelevant. And it's actually quite ridiculous. Our people are paying attention. They are watching who is willing to use that power in an interest of Hawaii and in an interest of good, and in the interest of addressing the history of wahine and indigenous exclusion from positions of power and in our courts. Mahalo.
Thank you. Let's see, the other person we skipped over somehow or wasn't here yet, it was Jackie Esser.
Hello, good afternoon, everyone. Chair Rhodes, Vice Chair, members of the committee. My name is Jackie. I'm here testifying in strong support of the appointment of Dan Gluck to the ICA. There is no doubt that he is highly qualified to serve. He has vast experience as a litigator and as a public servant. I take issue with the chart that has been being generated that shows him less experience based on the sheer numbers of appellate filings, even assuming if those numbers are correct. I too am a government attorney, and I am on, if you go to eCourt Kakua and look up my attorney number in the case filings, I will be listed on numerous of cases that I don't necessarily represent. Dan Gluck was not a government attorney, so he doesn't have this. Some of the other candidates with those high numbers are. And the number of appeals filed is a measure of experience, but it cannot be looked at in a vacuum. Mr. Gluck has a wide range of experience, which together all serve him to make him a great appellate judge. He clerked as a Supreme Court law clerk, which no one has been mentioning, but he's basically done the job which he will be appointed to do. He wrote opinions for a Supreme Court justice. He knows the ins and outs of an appellate court. He has extensive civil litigation experience as well as criminal experience through his work at the ACLU, as well as immigration experience. And so I strongly support Dan Gluck. I ask that he be nominated. He is the most intelligent, diligent, decisive, and compassionate person I know, and he will be an outstanding asset to the ICA. Thank you for the opportunity to testify.
Thank you. Let's see, back to the list. Next up is Jennifer Yamanuha.
She just left the meeting, Senator.
Okay, she was in support, or is in support. Elena Bryant.
Aloha Chair, Vice Chair, and committee members. I'm Elena Bryant, testifying in opposition in my personal capacity as a member of our state bar since 2011 as a Native Hawaiian woman and as a mother. I clerked at the ICA for 3 years for 2 judges and at the U.S. District Court in Hawaii for nearly 2 more years. I've done civil litigation in the family court system for over 4 years, and I currently do complex civil litigation on environmental and Native Hawaiian legal issues before all of Hawaii's courts. My opposition is not personal to the nominee. He's a nice man. He's done a lot for our community. My opposition stemmed from the blatant and systemic problems in the nomination and appointment processes for our state judicial bench that you, as the Committee on Judiciary, have the power to fix. First, confirming this nominee would set an extremely low bar as to the minimum qualifications for our highest courts. This nominee lacks the practice experience necessary to be an ICA judge, especially when compared to others on the shortlist. Appellate judges review the decisions of lower courts to identify trial court error, so they must be experienced and well-versed in the minutiae of the law, the applicable rules, and the trial court processes. This cannot be learned in a book. It's achieved through actual courtroom practice and experience. I learned the importance of lived experience when I left my appellate clerkship to do civil litigation. It's one thing to read a transcript from a trial court proceeding on appellate review, but it's an entirely different thing to be in the trenches litigating a case and creating that transcript. This practice experience is key at the appellate level when reviewing the decisions of another judge and identifying and ruling on trial court errors. As a civil litigator, I've also practiced before judges who lacked relevant practice experience, and it's extremely difficult as an attorney to have to educate a new judge on the applicable rules and processes while litigating your case. There's no room for on-the-job training at the ICA. Second, I oppose this confirmation because of the appellate bench's lack of diversity. In a 2018 Civil Beat article, Governor Ige said, and I quote, "The judicial branch will better serve the people of this state when it truly mirrors our diversity." He asked underrepresented groups to apply, and they did. Then he ignored these highly qualified Native Hawaiian and Filipino candidates and selected the only white male and least qualified candidate on the list. What message does this send to these women, to all brown women, to little girls like my own daughter? You can argue before our highest courts, but you'll never be invited to sit on the bench. Intentional or not, the damage is the same. It's been over 175 years since a Native Hawaiian woman has served on Hawaii's highest court. I urge you to hold the governor accountable and deny this nomination. Mahalo for your time.
Next is Kelly K. Lee Ponce. I'm sorry, I don't know how to pronounce her last name. Right.
Aloha kako, it's Ponce.
Ponce, okay.
Thank
Please
you.
proceed. Thank you.
Thank you. Aloha, I share this testimony to express my concern about the lack of representation on the higher courts for Native Hawaiian women, of which I am one. I have been practicing in our jurisdiction in good standing for 14 years. And to date, I have never seen a Native Hawaiian woman get confirmed to one of the appellate benches. We now have 3 viable candidates who have the experience, the skill, and the ability to be outstanding ICA judges. But instead of testifying in favor of any one of them, I'm forced to testify, lamenting the fact that none of them were selected. As many people have said today, 70% or more of Governor Ige's appointments have been white or Asian men. To be frank, this is a very poor record on diversity and inclusion. When reviewing the numbers and the body of the work of the candidates, I believe the Native Hawaiian women, Tara Gifford, Summer Kupau Oro, and Sonia McCullen, are statistically speaking, the more experienced, more well-rounded, and better practiced people who are more deserving of this position. And therefore, I also believe that the most recent appointment is an example of the exclusion of Native Hawaiian women from the bench. We hear this saying, you know, moving the goalposts. We're changing what the criteria is needed to get a certain job. And I think that's what's happening to our candidates in this process. They are very well qualified and they're not getting a look. I don't know why that is, but the conclusion I draw based on the statistics is that they're being ruled out just because they're different. Inclusion in our courts should be a priority. Inclusion for women, inclusion for the cultural perspective that Native Hawaiian attorneys provide.
Okay.
The bench should look like our larger community.
Thank you very much. Next up is Keani Rollins Fernandez. Good afternoon.
Aloha, Chair Rhodes, Vice Chair Keoha Kalole, and honorable committee members. Mahalo for this opportunity to testify in strong opposition of GM1 in my individual capacity as the Maui County Council Vice Chair, Council member from Molokai, and a member of the community that would experience harm by the approval of this nominee. I was taught that when you hear from an injured group, it's imperative that you really listen. A previous testifier brought up social justice. Mahalo, Senator Mercado Kim, for acknowledging potential repercussions we as women risk in speaking out. Mahalo, Senator Favela, for citing the issues of gender equality and equity. As a Kanaka Oiwi, Filipino, female elected official, I can attest to everything that you said. The bar for us is 10 times, 100 times higher. The testifier said the nominee will advocate for women's equality. Well, then I would like to see that advocacy today. I ask the nominee to advocate for equality right now by withdrawing his name. Senators, I hope you agree that our people deserve the most qualified applicant. Since there are no codified requirements that determine a qualified candidate, Kuleana rests solely on your interpretation. It has been over 20 years since a Native Hawaiian has been appointed to serve on the Hawaii Supreme Court and nearly 30 years since a Native Hawaiian has been appointed to the ICA. We have been collectively deprived of so much without the experience, perspective, rootedness, and ike kupuna that Oiwi bring with them to court. Please don't let anyone dismiss this issue as one that's just race. It's so much more than that. How many times in the past were more qualified applicants Native Hawaiians, but were deprived of that opportunity? How many times have Hawaiians and other disenfranchised, underrepresented communities been sidelined through this political process? Mahalo for your service, and I ask that you please be zealous advocates for us today and make the courageous decision to vote to recommend disapproval of this nominee. Mahalo.
Thank you very much. Next is Camille Kaimalia Kalama. Good afternoon.
Good afternoon. Aloha mai kapo, Chair Rhodes, Vice Chair Keoha Kalole. I know we have limited time and I just want to make a few points to add to my written testimony that I submitted. Your committee is tasked with confirming a nominee that will occupy a seat on our appellate courts for at least the next 10 years, the next decade. Likely, he'll be confirmed for another 10 years and possibly more. So we're talking maybe 10, 20, 30 years on this bench, and you will have missed that opportunity to correct the government's action, to correct the selection that was put before you. I sure don't like being in this position. I imagine that you don't either. But if you don't stand up and take a side of justice right now, you will be complicit in that decision. And I hope that you won't. One of the testifiers brought up that Native Hawaiian voices are diverse. Our communities are diverse. In fact, Hawaii's voices are diverse. And that is absolutely true. And yet, not a single Native Hawaiian voice, not a single person of color is represented on our appellate courts. It's absurd. It has no reflection of our actual community. To think that we need to simply focus on this one candidate before you and ignore what's really going on here is really disturbing. When it comes to actual experience, if we just look at the candidates, that's what's being brought up today. Sure, we are at the point where the governor has selected this candidate to put before you. And you're asking us, or we're being asked by others and supporters, to ignore everyone else, to ignore everything else that has gone on that has led us to this point. And I'm asking you not to ignore that, to do your job as a check and balance on the government, to do your job and correct the injustice that's happening today.
Thank you very much. Next up is Robert Harris. Good afternoon.
Good afternoon, Chair. Thank you for the opportunity to testify. It's my pleasure to strongly support the nomination and ask that you confirm Dan Gluck to this position. I had the opportunity to clerk with Dan Gluck at the Hawaii Supreme Court. I clerked for Justice Samantha Koba. He clerked for Justice Duffy. The interactions at the time at the Supreme Court were tense. There's the largest backlog of cases ever in the history of Hawaii at the Supreme Court. The workload is tremendous. There were great tensions between the different judges, unfortunately. I found interactions with Dan to be some of the most enjoyable. He was genuinely curious, he was fair, he was intelligent. He demonstrated all the attributes you'd want to see in a judge going forward on an appellate level. His experience is incredible. If you look at his commitment to public service, he has direct experience helping the underserved, helping the homeless, not only through his work as the senior staff attorney at the ACLU, but as a pro bono attorney, actually taking time on his weekends to help people with some of the most dire issues. It represents the true ideals of what is a lawyer to help our communities grow better. Moreover, if I were looking and judging his candidates, I would look at his ethical experience with the number of issues that we've seen in the media, from the Kealoha trial to direct investigations and a number of different actions at the C level. Dan has the ability to represent to the public the highest principles of ethical integrity and to be able to be the voice at the judicial system for those concepts of fairness, equality, and appropriate ethics. Finally, I'd just like to briefly address the issue of experience. Again, you've heard a number of Dan's colleagues who've interacted with him directly in cases, both with him, against him, and just basically watching him work. He is truly somebody who can hit the ground running and understands the issues well.
Your time has expired. Thank you.
Thank you, Chair.
Next up is Heilani Sonoda Pale for Kalahui Hawaii Political Action Committee. Good afternoon. I think you're still muted. Oh, no, I'm sorry. Go ahead.
Aloha Chair Rhodes and Vice Chair Kehokalole, members of the committee. Mahalo for the opportunity to testify. Kalahui Hawaii Komiki Kalai Aina stands in more strong addition to this appointment of Dan Gluck. And I just want to say that a lot of the
we'll have to give you a little more time because you broke up right as you were saying whether you supported or opposed him. So please say that again.
Okay. Aloha, everyone. So Kalahui Hawaii Komiki Kalai Aina submits testimony in strong opposition to the appointment of Dan Gluck to the Court of Appeals. And I want to say that a lot of what we shared in our testimony has been so eloquently stated by many of my comrades here in the hearing, and wonderful, intelligent Native female attorneys who are speaking truth to power today. And I'm just so, I'm so touched by a lot of the testimony that I heard today. I want to say that.
Okay.
But I do want to point out that racism is systemic, and this is not about Dan Gluck. If you look at the statistics, Hawaiians, nobody brought this up, but Hawaiians are overrepresented in Hawaii's prisons, jails, and juvenile detention facilities, and it's been that way for decades. And that speaks to the racism that is prevalent in the judicial system. And I want to also state that as Kalahui Hawaii, we do represent 20,000 families that are on our rolls. So we do speak with a voice for Kanaka Maoli people who have since 1893 owned the worst socioeconomic, health, and incarceration statistics here in Hawaii, in our own homeland. Aloha, everyone. Mahalo for the opportunity.
Thank you very much. Let's see. We have Summer Silva, president of the testifying for Native Hawaiian Bar Association. Good afternoon.
Yes, thank you. We submitted testimony in opposition to this nomination for the reasons stated, but I'd like to address a few additional points. First, I want to speak to the nominee's pedigree and what that affords, because I know what the allure of an Ivy League education has on people. I chase that prestige too. I actually share an alma mater with the nominee. And truth be told, I did so under my single mother's urging, because she knew the doors that it would open for me if I did. She did not trust the system, the status quo, to course correct their bias and their privilege and access to power for me, a Native Hawaiian girl from Waimanalo, no different from the Native Hawaiian Wahine candidates from Maui and Big Island who got passed over by the governor on this nomination. In some ways, I thank her, my mother, for having that foresight, even if based out of her fear and knowing that my career ceiling might be limited without that pedigree. The opposition to this appointment, though, is a resounding rejection of that status quo that breeds exactly that kind of fear and cynicism. And I could not be more proud that at this moment, that is the pushback. That the request is, you shouldn't have to uproot yourself to be given fair and equal consideration for judicial appointments deserving of your skill, experience, and your achievements, your perspective, accomplishments that set you literally head and shoulders above the others in your field. That how hard you work and who you serve, not who you know, will count in ways meaningful, that are valued and recognized, and will serve the ends of justice, of access to justice in particular for the masses in this state. In this case, affirming judicial diversity means bucking politics and practices that would otherwise seek to advantage a candidate with comparatively underwhelming skills and experience, primarily because of his race, gender, class, pedigree, and political connections. Please do not disadvantage the other candidates who, if this were a level playing field based on merit alone, would be awarded for their achievements and not their privileged access to elite spheres of power and influence in this state. That is the appeal of this opposition. Thank you.
Thank you. Members, that's been 10 more testifiers. Let's go ahead and ask questions now. Any members have any questions?
Chair Rhodes, I have a question for Dr. Osorio, if she's still present.
Senator Ocasio, go ahead. Are you still here, Dr. Osorio?
Yep.
Yes, go ahead.
Mahalo for your testimony, Dr. Osorio. I just wanted to ask you to speak to and perhaps expound on historical trauma and how this current choice before us, or whether this current choice before us kind of catalyzes that or is a perpetuation of that today.
Absolutely. Mahalo for your question. I've got to say that not a single Native Hawaiian and Native Hawaiian woman that I know was surprised by Ige's nomination, which speaks actually to the way that this history of racism and sexism and anti-Hawaiian choices by our state and government have come to be normalized. And that is a kind of demonstration of the historical trauma. I think Summer Silva's testimony speaks really beautifully to how our people have tried many different ways to kind of to better ourselves by following these these very specific metrics of success and achievement and making connections. And even in doing that, have been disqualified from being able to serve our communities because of the decisions that are made in these kinds of spaces. And so, yes, we have an opportunity here to recognize that historical trauma, and personally, each and every one of us recognize the way that we're complicit in that. And today's decision could go, even though it's one nomination, it could go a long way in helping to at least face justice in that sense. So mahalo for your question.
Members, any other questions? I do have one for Dr. Osorio too. So it wasn't clear to me. You were criticized? I'm trying to say this in a neutral way. So your critique of Governor Ige was that in the court system, he was only overwhelmingly appointing AJA and white men, or was that? The reason I ask is because there's other appointments the governor has, of course, and the person who sits next to me on the Senate floor, Senator Misa Lucha, was appointed by governor to replace an AJA senator who unfortunately passed away a year or so ago. And I know for sure in that case there was at least one AJA man that was on the list that he could have chosen from. So I guess I was curious about, were you referring just to the judiciary, or is the critique broader than that?
It's my understanding that his appointment record represents that 71% of all of his appointments are male and 71% are white and Asian American, right? So that doesn't mean that 100% of his appointments have been so.
For the judiciary or for all of his appointments?
For all of his appointments.
No, I hadn't seen that. Okay, well, it's not been my personal experience in the legislature, because the other appointment he made recently was Senator DeCoit, and I don't know what his list was there. So it might have been he had no choice but to name a Hawaiian or part Hawaiian. But I did not get the sense from him that he did it grudgingly. And then the person he replaced Representative DeCoit with was, I believe, a Hawaiian woman as well. So that's why I was asking. Members, any other questions? Yes, Senator Keokalole.
Dr. Osorio, are you aware of the demographic composition of the governor's cabinet?
No, I am not.
So you're not aware of how many Filipinos there are in deputy or agency administrative positions, are you?
No.
And you're not aware of how many women there are in cabinet positions in this administration, are you?
No.
And you're not aware of how many Hawaiian agency heads there are in departmental cabinet administration positions, are you?
No.
Thank you.
Oh, sorry, Senator. I thought you were going to tell us the answer to all those questions. I would be interested. In any case, members, any other questions? All right, we'll go ahead and move on. Thank you, testifiers. And I'm sorry, Senator San Buenaventura. I sort of had said that I would take questions from you after the members. Do you have anything?
No, I think the senators had asked the questions that I would have asked. So. Okay. Thank you very much for acknowledging me.
Okay, yeah, we'll move on then to Zuri Aki, Public Policy Manager for the Council for Native Hawaiian Advancement.
Hello, can you hear me?
Not very well. It's very soft.
Okay, let me try to speak a little louder.
There, that's better. That's better. We can't see you, but we can hear you better.
Something seems to be going on with my video, but aloha, Chair Rhodes, Vice Chair Keohalole, and the senators of the Committee on Judiciary. My name is Zuri Aki, and I will be providing testimony on behalf of the Council for Native Hawaiian Advancement. CNHA strongly opposes this measure. CNHA's opposition to Mr. Gluck's confirmation is not predicated upon the issue of whether Mr. Gluck is qualified to serve as an associate judge upon the ICA, but rather whether the nomination and confirmation of more diverse professional expertise and experience will result in an improved jurisprudence that better recognizes a variety of people and lived experiences, and whether Hawaii would be a better place for it. CNHA strongly believes so. According to the Center for American Progress, the judiciary has a legitimacy crisis derived from public trust issues associated with the lack of judges representing historically underrepresented groups. The vast majority of sitting judges, including within the appellate system, are white men. The United States is yet again at another critical stage in addressing its long-standing issues of racial inequality. Communities across the nation rallied to dismantle institutionalize racism while others defiantly uphold them. The state of Hawaii continues to uphold systems of oppression and institutions of racism. No other example of this is more evident than in the plight of Native Hawaiians in their own homeland. We know the story. White men incapable of accepting the leadership and professional expertise of a highly educated Kanaka Maoli queen endeavored to overthrow her government and then sought to erase Native Hawaiian identity. They established systems of oppression, built institutions of racism, and they were never dismantled. Today, Native Hawaiians are overly represented within Hawaii's criminal justice system. We are not more likely than any other ethnic race, ethnic group or race to commit a crime, but we are more likely to be arrested, incarcerated, and sentenced to longer terms than any other group. The issue correlates with the lack of Native Hawaiian representation among the judiciary. Diversity adds immense value to the judiciary. Here, the only white male candidate was nominated for consideration to the ICA. Time and time again, we have heard that he would be the voice of equality. That's a fallacy. Diversity speaks for itself, and our historically underrepresented groups are being silenced by this nomination. Mahalo nui loa for the opportunity to provide testimony.
Thank you very much. Next up is retired Associate Justice Stephen Levinson.
Thank you, Chair, members of the committee. I appreciate this opportunity to testify orally. I did submit written testimony, and it speaks for itself, and I don't wish to repeat it, although I would call particular attention to the second and third paragraphs of my testimony. As you've just indicated, I am a retired Hawaii Supreme Court Justice. I served for 17 years. The first 8 of which were with Chief Justice Ronald Moon, a Korean, Justice Robert Klein, a Hawaiian, Justice Paula Nakayama, an American of Japanese ancestry, and Justice Mario Ramil, an American of Filipino ancestry, born, if I remember correctly, either in Manila or Quezon City, where my father was on the day of his birth, roughly 6,000 miles away from me. I know what it takes to be an appellate court judge. I know what the attributes are that make for a great appellate court judge. I know Dan Gluck. I should mention that the historical grievance, which has been articulated eloquently by so many of the testifiers here, is real. And if I could personally fix the situation, I would do it. I think there is a sadness and an irony that by virtue of the nature of this proceeding, we are...
Justice Levinson, I apologize, but your time is up, and if I start making exceptions, then all kinds of bad things happen. So thank you very much.
If anyone has any questions, they're free to ask.
Thank you. Next is Kurt Klein.
Aloha and good afternoon, Chair, committee members. Can you hear me?
Yes.
My name is Kurt Klein. I'm an attorney licensed to practice in all courts of the state of Hawaii, and I oppose the nomination of Mr. Gluck. My practice area is civil litigation with a focus on commercial law and business disputes. You know, I was surprised by the governor's choice, especially given the appellate level appointment for which Mr. Gluck is being considered. I represent both plaintiffs and defendants in legal actions that from time to time end up on appeal before the Intermediate Court of Appeals and the Hawaii Supreme Court. You know, I had more cases in litigation and on appeal in my first year or so of practice than Mr. Gluck has under his belt today. My clients are members of the public, and they're the ones who will be affected by the nomination of Mr. Gluck. If my client's case ends up on appeal before the ICA, it means that they likely have or will incur significant legal fees. At the appeal stage of the case, my clients expect experienced jurists to review the trial court's rulings and findings and make the right call. My clients have encouraged me to oppose Mr. Gluck's appointment on the basis of his lack of judicial experience, and I concur with their assessment. It would send the wrong message to the public if this nominee is confirmed. It's nothing personal. On the State Ethics Commission, Mr. Gluck has done his job very well, contributes a great deal of energy and expertise to his important job as a public servant. However, Mr. Gluck lacks the wide range of legal experience that comes from a diverse law practice, and that would be expected of a candidate for any appellate judgeship in this state. He has never been a judge either. So correcting legal errors and ensuring litigants a fair trial at the appellate level would require on-the-job training. Often in writing opinions, judges and justices consider the facts and the law, as well as their experiences on the bench or in the courtroom to weigh important legal outcomes. What experiences will Mr. Gluck rely upon? Being an excellent administrator in a limited area of the law is not enough, in my opinion, to support the governor's nomination of Mr. Gluck. For these reasons, I ask that you do not extend your support to Mr. Gluck as an associate judge of the ICA. Mahalo.
Thank you. Members, I'm remiss, and I forgot to tell people that the administrator of the courts, Rod Miley, has been sitting in with us today. And as a resource for statistical purposes, if you do have questions about just factual stuff, the judiciary doesn't take a position on judges like this. So in any case, just wanted to acknowledge that he's here, and if members do have questions, he's available. Okay, next is Jermaine Myers.
Aloha, Chair. Can you hear me?
I could. Yes, go ahead.
Okay. Aloha. My name is Jermaine Myers. I am a Native Hawaiian woman. I'm a Nanakuli Hawaiian Homestead lessee. I'm here to strongly oppose Daniel Gluck's confirmation, and I strongly oppose it for the sake of diversity and minority, for there to be a proper representation in the court system, in the judicial court system. Chair, when my grandmother was born in 1912 and she died in 1986. And as a Native Hawaiian woman, I had studied women's suffrage. And in the US Constitution, when my grandmother was born in 1912, in the US Constitution, women were not allowed to vote. And at that time, women was not allowed to vote. Women were not also allowed to own land in the United States. And since the Constitution of the United States has been changed and is representing now women and diversity, allowing women to vote, and also the Black men and Black women to vote, the laws have changed. And it is important that diversity and minority be represented in the judicial system for those exact same purposes. When my grandmother died in 1986, the laws had changed to allow her in the United States to own property. And so I really feel that the judicial system should also represent that. And I thank all those that had strongly opposed for those same reasons, that you are at the cusp of a historical moment. And someone had stated earlier that it's at the privilege of the governor that he nominated Mr. Gluck from the short list. But this is not a dictatorship. The reason why we're here today and I'm standing in front of you in virtual is because—
Thank you very much. That your time has expired. Thank you. Next up is, I'm sorry, before we go to the next testifier, for those of you who are here for JC1 for Leslie Maloyan, I would estimate, this is a guesstimate now, that it will be it'll be at least 2 o'clock before we get to JC1. So if you want to go away and come back, that's fine. I won't start that part of the hearing until 2 o'clock. Okay, next up for GM1 is Charla Manley.
Thank you, Senator Rhodes. Good afternoon. It is something of a misnomer to call the nominee white. In fact, white nationalists would abhor being lumped together with Mr. Gluck, a Jewish man. Anti-Semitism and hate crimes against people that share his ancestry have surged in recent months and years. Neo-Nazis marching on Charlottesville in 2016 were shouting anti-Semitic remarks. Anti-Semitism is the oldest racism. Perhaps because Mr. Gluck's ancestors are part of that sad legacy, he has a desire for justice and He has devoted his career to serving the needs of people in this state who have been underrepresented and persecuted. He represented a Native Hawaiian man pro bono, free of charge, who was fighting to prove his rights to ancestral lands on Maui. He provided briefs to support the rights of Native Hawaiian prisoners to speak to their attorneys without guards at a private prison in Arizona listening in. It is a sad and ironic situation that the outcry that's made today that is quite justified is being made against a nominee like Mr. Gluck. And I support his nomination. Thank you.
Thank you. Next is Juanita Brown Kawamoto speaking for the Hawaiian Affairs Caucus of the Democratic Party of Hawaii.
She's present, Senator, just not responding.
Hello, can you hear me?
I can hear you. I can't see you. But you're muted. You're muted again.
So, we're muted.
Okay, you're not muted. Now you're muted.
Senator?
You're not muted now, but we can't see you.
Okay, but may I speak?
Yeah, go ahead. Go ahead.
If you can hear me, Kent.
Yeah,
okay.
can.
Mahalo. And I'll be brief. It's, we will stand on our testimony as the Hawaiian Affairs Caucus of the Democratic Party of Hawaii. Strong opposition to the GM nomination of Daniel Gluck to the Intermediate Court of Appeals of the state of Hawaii. And what I'd like to highlight, because so many, we share the very clear and concerning issue of this nomination in the light of so many qualified, highly qualified Native Hawaiian women. A thing that stands out to us in our group was we had discussion about Mr. Gluck, and we had discussion about the Native Hawaiian candidates. And some thought, well, perhaps Mr. Gluck would be thoughtful, could be reasonable with looking after our Native Hawaiian issues. And then one of our very strong advocates stood up and said, is this paternal? Do we have to wait for somebody to represent us? Are we not qualified to represent ourselves? And so, again, going forward and saying 20 to 30 years of truly no Native Hawaiian representation on this Supreme Court system is unacceptable, and that it is time for our Hawaiians to have decision makers out there help us with the huge disparities that we suffer from. That has been a lot of a problem that was brought by Western values and ideals. And our people have the capacity and ability to speak for us because they live Hawaiian and they understand. That's the very unique thing that stands out to us most of all. We have the people there who can truly represent. And, you know, Hawaiians have given so much.
I don't think you can see the countdown clock, but your 2 minutes are expired. Thank you.
I'm sorry. So I'll just end with.
Thank you very much. Members, any questions for this last group of testifiers? Seeing none, the next group.
Hey, Chair.
Yeah. Oh, Senator Gabbard, go ahead.
Yeah, Chair, for Justice Levinson. Is he still with us?
Senator, he just left.
He left.
Oh,
sorry.
Okay. It's okay. Thanks.
Any other questions? Okay. The next, there's pages and pages of people who testified but did not sign up for Zoom. So I'm going to start reading them at least. I may wear out and give up after a page or two, but I want to give people both on the committee and off the committee a sense of where the opposition and support is coming from. Michael Galoyu Sr. in support, James Blaine Rogers in support, R. Brian Black in support, Jennifer Shimada Hausler in support, Evan Mandel in support, Claire Connors in support, Michael Livingston in support, Ruth Chumi in support, Kipukai Kuali'i from council member from Kauai in opposition, David Nakashima in support, Harry McCarthy in support, Ian Barrera Sandri in opposition, Keone Kealoha Alvarez in support, Mark Davis in support, Louis Ertischik in support, Eric Vanderwerf in support, Bronson Kainoa Kiyoshi Azama in opposition, Kaorile Kaimi Pono Hano in opposition, Benton Keali'i Pang in opposition, Lisa Lee in opposition, Sat Khalsa Friedman in support, Jonah Bobolin in opposition, Nancy Knifer in support, Nicole Cristobal in opposition, Andrew Foy in opposition, Lilia Makaila in opposition, Kalina Charlene Halani in opposition, Key Campbell in support. Susan Yoza in support, Holly Shikata in support, Elizabeth Kent in support, Amy Rice with comments, Cheryl Burkhardt in opposition, Marissa Baptista in opposition, Wayne Chung Tanaka in opposition, Catherine Coswell in opposition, Carrie Okinaga in support, Filipino Law Students Association in opposition, James Duffy Jr. in support, Rainer Dralty in support, Wendy Green comments, Jan Tamura in support, Gwen Kay in opposition, Virginia Chalk in support, Cleota Brown in opposition, Kamaka Parker in opposition, Jocelyn Doan in opposition, Malia Marquez in opposition, Shonda A. Makaimoku in opposition, Noelani Sugata in opposition, Charlotte Manley, we heard from her already in support, Joanna Miley Pokipala Resurrection in opposition, John Robert Egan in support, Jocelyn Lee in opposition. Lisa T. Maruyama for the Hawaii Alliance of Nonprofit Organizations in support, Shannon Adia in opposition, Shauna Springer in opposition, Emily Bradford in support, Jason Kamisugi in support, Audrey Hidano, Deputy Comptroller in support, Brian Powell in support, Krishna Yajaram in support, Lawrence Tong in support, Anna Pohl in support, Carly Minner Cole in support, Ashley Galagak in opposition, Eden Lewis in opposition, Forrest Rizal in opposition, Sharday Freitas in opposition, Brooke Abola in support, Rachel Wong, comments only, Nancy Creedman for Domestic Violence Action Center in support, Priscilla Fuentes Smith, comments, Latani Peltier in opposition, Mia Obsiana in opposition, Doris Lum in opposition, Antoinette Lilly in opposition, Kowena Bupre in opposition, Taylor Brack in support, Marcus Landsberg in support.
Sure, I can tag in when you're ready.
You got the list there?
Yeah.
Okay, go ahead. Take the next page. Page 6, all yours.
Page 6, Sheena Crail in opposition, Dana Viola in support, Wheela Barnett in opposition, Henry Booth in opposition, J.C. Mikulanik in support, Kikoa Beaupre in opposition, Chester Hazelwood in opposition, Shannon Lena Ala Cosmo Reyes in opposition, Kainalu Stewart in opposition, Troy Andrade comments, Sai Samoa Gray Price in opposition, Melinda Garma comments, Becky Gardner in support, Justin Guy in support, and the following individuals on page 6 of the testimony list, all in opposition: Punihe Laip, Francis Salvado, Brandon Maka'aba'a, Deborah Kaiwi, Kalani Kalima, Cody Nemeth, Alex Miller, Mahina Poipoi, Tiare Lawrence, Lonnie Eckertad, Michele Tankayo, Jeff Kiko Hascheltz, Carrie Long, all in opposition. On page 7, McKenna Fernandez in opposition, Ki'ikaho Hanahano in opposition, Ka'apuni Aiwohi in opposition, Shelly Stevens in opposition, Sarah Freistat Pajimola in opposition, Melly McPherson in opposition, Noelani Ahia in opposition, Ridale Medina in opposition, Faye L. Wallace in opposition, Pauline Jean Paleka Ku in opposition, Lori Buchanan in opposition, Rudy Koch in opposition, Duke Ahun in opposition, Jeanette Kaina Peters in opposition, Gordon Lindsay in opposition, Gregory Kahn in opposition, Lakia Poi Poi in opposition, Lisa Sekai Darcy in opposition, Christopher Fritzius in opposition, Rosie Aligado in opposition, Dr. Noelani Goodyear Kaupua in opposition, Shane Senensi in opposition, Sybil Lopez in opposition, Jordan Hawker in opposition, J. Michael Seabright, Chief U.S. District Judge in support, Mavis Oliveira Medeiros in opposition, Susan Okimalwe, Senior U.S. District Judge in support, and Leslie Harvey in opposition.
All right, I'll do a couple pages. Next up is the Hawaii Filipino Lawyers Association in opposition.
Chair, is this really necessary? Can't we just say how many people opposed in the interest of time?
Yeah, okay. So do we have a...
Crazy.
Well, we have 2 more pages. Why don't we just finish? It'll take another 2 minutes. Catherine Betts in support, Paul Alston in support, Jennifer Rose in support, Robin Chun with comments, Biliami Tauatevalu in opposition, Clarence Ching in opposition, Victor Gregor Limon in opposition, Russell Akira Suzuki in support, Hailama Farden in opposition, Annalisa Bernard in opposition, Louisa Lee in opposition, Daryl Fujiwara in opposition, Sandra Ann Kaio Nalani Pratt Aquino in opposition, Bridget Mowat in opposition, George Burnett in opposition, Yulima Leigh McFarland in opposition, Aiko Yamashiro in opposition, Kyla Shaw in opposition, Jennifer Jenkins in opposition, Michelle Cabalsa comments, Laura Bowles in opposition, Lori Akana in opposition, Justin Hura in support, Dayton Cito Myers in opposition, Deja Ostrowski in opposition. Let's see, Tia Anaya in opposition, Elima Leigh McFarland in opposition, Kimberly Guidry in support, Chantel Cambia in opposition, Henry Michael Kai Kidder in opposition, Renee Goff in opposition, Matthew Charles Tuth III in support, Stephen Thomas in opposition, Monique Cariaga in opposition, Deborah Havar in opposition, Amy Ono in opposition, Micah Kaimana Pakatan in opposition, Kaupena Kalima in opposition, Sean Joseph Chu with comments, Jalen Kanani Afia in opposition, Ikaika Rosa in opposition, Michelle Moore in opposition, Kelsey Pickard in opposition, Ariel Keo Puolani Ani Angwai in testifying for Lira Organics in opposition, Kelly Osorio in opposition, Manila Evans, Anella Evans in opposition, Shannon McClish in opposition, Lauren Isaki Kua in opposition, Penelope McKinsey in opposition, Raylene Pratt in opposition, and Levi Ho'okano, President HSBA, testifying for the Hawaii State Bar Association, who I believe is here. Yes, go ahead.
Aloha, Chair Rhodes, Vice Chair Kehokulole, and members of the committee, and Senator Stan Buenaventura. Levi Ho'okano on behalf of the Hawaii State Bar Association. We're testifying with comments that the board, we've met to discuss the qualifications of Mr. Gluck, and after review of his experience as a totality and the documents submitted by him, and after interviewing him, our board has found Mr. Gluck to be qualified. We've provided information within our testimony that we've reviewed to support that conclusion, and I will be available for questions if any of the senators has any for me.
All right, thank you very much. Thanks for waiting so long. Members, questions? I have a couple of questions for you, Mr. Ho'okano.
Yes, Chair.
So Mr. Gluck has been criticized for having less trial court experience than other members of the pool he was selected from. HSBA gave him a qualified rating anyway. Why didn't the lack of courtroom experience move him from qualified to unqualified?
So, Mr. Chair, the the evaluation of your professional experience like that is, while courtroom experience is desirable, is not the only criteria under professional experience. We also look at a total of their practice within the legal field, not necessarily occurs within the courtroom, of significant and distinguished accomplishments outside of the courtroom within the field of law can also qualify a candidate for a qualified rating in that area.
Okay. A follow-up to that, did the court being applied for make a difference in HSP's decision? If Mr. Gluck had been nominated for a trial court, would the courtroom experience weigh more heavily?
I can't really go into a hypothetical like that, Mr. Chair, but that we still would look at the totality of his experiences to make that determination, as well as solicit input from our members.
Okay. Can you tell us the number of members that did have an opinion about Mr. Gluck?
Yes. So we did receive, we received 13 total comments. 8 of them were positive. 3 what brought up his qualifications, the lack of qualifications, and 2 were neutral.
And 2 what? I'm sorry?
We're neutral.
Neutral. Okay. 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 Thank you, members. Any other questions? Senator Keola Kalole.
Oh, actually, I'll yield to Senator San Buenaventura because she raised her hand first.
Oh, okay. Go ahead. Go ahead, Senator San Buenaventura.
Oh, okay, thank you. And I know I'm not a judiciary committee member, so I appreciate that, Vice Chair Keola Kalole. But basically, I think one of my concerns with the HSBA's recommendations and qualifications, Mr. Ho'okano, is whether or not you folks have actually polled the practitioners of the area. So when you talked about the 13 comments, how many of those were practitioners of appellate courts or trial attorneys?
Senator, so our comments that we receive at the board are anonymous. Unless they disclose within their comments themselves, we can't identify that kind of information. We do send this information out to our entire membership. So we hope that our membership takes an active role by submitting their comments to the board so that we have as much information as we can when we evaluate the nominee.
Okay, so how many people in the board actually vote to determine whether or not if somebody's qualified or unqualified?
Sorry, Senator, you broke up a little bit there, but our voting process at the board over there, we have anonymous voting, so I cannot tell you what the default result was.
Okay, so when you determined qualifications, it was specifically on the resume itself as well as the comments and the interview, correct?
And also his JSD application we checked with his references that he submitted to our board to interview them about their comments about the nominee.
Okay, thank you very much. I may have future questions. Thank you, Chair.
Members, any other questions for HSBA? Senator Casio, go ahead.
Mr. Ho'okano, so how many members were asked to comment?
We send this information out to our entire membership, and that's about 8,000 members.
Okay, and out of 8,000, 13 responded?
Yes, Senator.
Could you? Okay, thank you.
Thanks, Senator Kim.
Thank you. How many people on the committee that voted?
Our board is composed of 22 members.
22
or
members?
21 members. 22?
Was it a unanimous?
I'm sorry, 21 members.
21. Was it unanimous?
Again, Senator, I can't tell you the result of the vote because it's a unanimous ballot. So I do not know the total vote count or how the votes were dispersed, just that it was a majority vote in favor of finding qualified.
Okay, I can see it's anonymous, but was it 12 or 10-9, or I mean, you can't tell us that.
I don't even have that information, Senator.
But that information is available?
It's not. It's an anonymous vote. So
is that number available? Is that number available?
I do not.
Correct number.
I don't think so, Senator.
Okay, thank you.
Senator Keokalole.
Mr. Holokano, aloha.
Yes, Vice Chair, aloha.
Have you been following the testimony?
Yes, I've been on the entire time.
Oh, how great for you. The question that I have for you is, as I went through the JSC application packet for the nominee, and then in this dialogue about case stats and its relevance and the assumptions and correlations that can be made as a result, it seems like in this dialogue there is a gray area here when it comes to preliminary matters that are not actually brought before the court, where the attorney has to note themselves for the record. In your evaluation of Mr. Gluck's qualifications, it seems like that might be relevant information. Seeing as how there's this large disparity in the type of practice action that we can track statistically and his years of experience. Did that come up in the board's deliberations?
I'm sorry, Senator. I want to clarify and make sure that I'm answering your question properly here. Are you asking whether the numbers, that chart that's been circulated around the internet, was considered by the board?
Sure. Why don't we start there?
Well, so our board's deliberations are conducted in executive session, and so they're confidential proceeding. But of course, that process, when we evaluated Mr. Gluck, we looked at his JSC application, and as somebody who's not a litigator, I rely on other people to inform me about what it means to have that relevant experience. And after evaluating the types of caseloads that he's had, his experiences since coming to Hawaii and clerking for the appellate court, for the federal district court, and for working in the field here with the ACLU, representing underrepresented clients and the indigent, those who cannot represent themselves. After evaluating all of that, the entirety of his experience, that was when we came to our conclusion.
So that's where the direction I'm headed is, if the Bar Association board was doing an assessment of the entirety of his experience, then how did they account for that gray area that was submitted by the testifiers in defense of Mr. Gluck's limited record from a case statistics standpoint? I think it was Mr. Winter or one of the other attorneys who testified in support for Mr. Gluck's nomination that pointed out that you can't track the entire, Mr. Kaprowski, I think, you cannot track the entirety of the nominee's depth of and breadth of experience, because so many of the things that he did were not filed in court. And so as a result, this committee is left to evaluate the personal, many of the personal anecdotal pieces of testimony, not just to assess his character and temperament, but to assess his actual legal record. And so I'm wondering if the board discussed that and maybe asked that question as well, and maybe asked for some clarifying information from the candidate in order to determine the quality of that gray area in his record.
Thank you, Vice Chair. Well, the candidate is here, and he can address a lot of those questions directly for you.
Oh, I'm gonna.
But with respect to the practice of law and the experience, not all areas of law is practiced in a courtroom. Those who practice in wills and trusts may not ever see a litigated estate planning matter, but they've practiced quite a bit in that area. So it varies greatly within each attorney's professional experience. So evaluating everything that he's done, like I said before, we have found the candidate qualified.
Okay, I guess the answer to that question is no. So I guess I'll be left with the supportive testimony and opposing testimony of the record, and then questions for Gluck himself. But I'm a little confused as to why a large question in Mr. Gluck's nomination has to do with what he actually has done. And for the Bar Association to not actually have investigated that significant area before they made a determination as to whether he was qualified or not seems a little bit problematic, given that only 13 people from the outside the board submitted comments on him. And this committee, and certainly I, as a probate and trust and estate attorney who does not practice in litigation, takes as a significant piece of testimony. So I'm wondering if, it seems like what you're saying is that conversation never came up at all. And I'm wondering if it's something that needs to, if there's some way to account for it in the process.
Mr. Chair, may I respond, please?
Yes, please do.
So in response to that, we do investigate everything, Vice Chair. Now, the candidate will provide us with a list of their accomplishments within their application. You may have seen it in the JSC application as well, and the information he provides on his resume. Now, within all of that, we do look at the cases that he's done. We interview the candidate and discuss those qualifications with him. And as he is here, he can also answer those questions for you. And in those discussions, we have determined, after the breadth of things that he has mentioned, that it is qualified.
They're both attorneys.
Thank you.
Okay, Senator Sanbuena-Ventura, go ahead.
Yeah. So I'm sorry. So Mr. Holcano, just to follow up, because I am an active member of the bar. I remember receiving an email from you. But I also know that whenever you folks make a request to the general bar to make a comment on a nominee, basically all you folks do is name the person. So we don't really see, as a member of the bar who doesn't, and you're talking about Daniel Gluck, who I know personally because I work in the Capitol, but if I were a practicing attorney in Hilo, I would never have really run across him because he picks and chooses as an ACLU director which cases he decides to go against. As opposed to me being a practicing attorney in Hilo, I run into attorneys all the time, and so I will be able to make a comment. So it does not surprise me. You have 13 comments. My question is, why is it that your procedure, especially for a nomination for a second highest court, doesn't, one, focus on the appellate attorney bar, because that are the people who is going to go in front of him? And two, why is it that you don't attach a resume when you ask for those comments to the general bar? Thank you.
Thank you, Senator. So we send out that information to all of our members, and we hope that our members would participate by sending in information. Now, we don't attach the resume because we don't have the resume at that time. We submit that email as soon as we get the name that is provided by the appointing authority, so that we can get that out as quickly as possible to our members, and so that they can submit comments within such a short window from the time that the appointing authority names their nominee to this hearing. We don't have much time, so we have to get that information out as quickly as possible.
Okay, so basically then, the comments are people who actually just have run into Dan Gluck. Because if you are not giving out the investigation, nor the resume to the rest of us, we don't know the shallowness of his experience. We don't know the fact that he picks and chooses the cases that he decides that he's going to actually win on, and which as opposed to trial attorneys.
I'm sorry, Senator. Is there another question? Okay.
So basically, I just want to point out that that is the problem with you folks' qualification recommendation.
Members, any other questions? Okay, so we will.
Chair.
I'm sorry, who's this?
Chris Lee.
Oh, sorry, Senator Lee. Sorry, couldn't see you. Go ahead.
No worries. Is my video on?
Say again?
Yeah. Oh, sorry.
Yeah,
sorry.
Go ahead.
Thanks, Mr. Holcano. I'm not as familiar with the bar's process and everything else. I think as some of the others who got more legal experience than I do, but is the process for vetting nominations the same? Is this process in this particular case the same as all the other judges that have come across our desk that the bar weighs in on?
Yes, Senator, it's the same. We follow the same procedures.
Okay, thank you. And then if I could do one follow-up, Chair,
Sure.
It would be best if maybe Ms. Perrin's available. She's still here?
Don't know.
I am here.
She said, go ahead.
Hello, I am
Thanks.
here.
So I've been sitting here listening to all of this, this whole time, and there's a lot of different perspectives on what constitutes this gray area of law, where people practice or don't. And again, I'm not as familiar, but I have to imagine, based on our work on other issues at the Capitol, that you probably know better than most. Can you quantify or qualify or just provide any sort of insight into what that actually looks like? Because there's been a lot of speculation so far, and no one's really, and certainly the nominee hasn't spoken to it. But
Yeah, certainly. So I was a clerk actually for Judge in Hawaii, and then I was also in civil practice for about 8 years before I came to the ACLU. I think the most important thing in listening to this gray area is that people don't realize that the ACLU of Hawaii received between 800 and 1,000 requests for assistance every year. Every single one of those letters was reviewed and analyzed, and we determined whether or not we were able to give assistance. Oftentimes, we would refer them to other organizations or to other counsel, but we're looking at 800 minimum per year. The other thing is that the majority of the cases that we took at the ACLU were not litigation cases. They were informal resolution cases. These dealt with things like as menini as whether or not somebody could wear a certain kind of shoe to a graduation, versus things that were much more significant, of whether you could actually create some sort of GSA, some gay straight alliance at a high school. There would be no record of an attorney of record in any of these things. We intervened as counsel for the client to engage in informal negotiations in order to bring resolution, not just for the particular client, but in order to change the policy for the particular agency or school that was involved. So as far as Dan's, he's probably dealt with thousands of requests for assistance, which is unlike being at a prosecutor's office or a defense, the PD's office. You're given a case, and that's your case, and that's your record. These are cases we look at, we analyze, and we determine whether or not we're going to take them.
so thanks. And then, Chair, if I could follow up with just one more person, if they're still here. I've been unclear on, obviously, this whole courtroom threshold, because it means a lot of different things to a lot of different people, but clearly there's some attorneys, at least in my experience, or some judges that have a great amount of experience who are not so great, and others who have little experience who are. Chiefly among them, I think Catherine Kealoha's dearth of courtroom experience doesn't necessarily make her, I think, judge material. I think that steps up. But so to that end, I apologize, I forget the name because my screen's black over here. But the former Ethics Commission head that testified earlier, whose name escapes me. She was one of the very few. I guess if you're here, hop on. Otherwise, I'll reserve my comment for another time.
Hello, it's me.
Hi, I apologize. What was your name?
My name is Susan de Guzman.
Oh, thank you. Okay, so sorry. I'm having some
problem.
technical issues. I can't even see my screen right now.
That's okay.
But for the ethics portion of this, for me, I understand, and it's frustrating. I think there's nobody wrong here in, I think, their intent and what the end goals are and values that we're bringing to, I think, a position like this, and what it means, I think, for our community, and how we prioritize what's important to us as a society here in Hawaii. But the other part of it, which hasn't been talked about yet, that I'm curious about, we have, to my knowledge, not a lot of people with backgrounds coming out of the Ethics Commission that really go anywhere. There might have been a handful of folks who moved on to other positions, of course, but it's so rare to have that in this context, right, in the judiciary. I'm curious from your perspective what value that brings to the table, and if there is perspective there that you are able to learn that you think might be applicable to this conversation.
Okay, as I was saying in my original comments that I started, there are a lot of duties and I guess skills that Dan and the other staff attorneys do at the commission that can be equated to the ethics commission with the 6 attorneys total. It's kind of like a small little law firm, but their specialty is the ethics code and the lobbyist law. So they deal with statutory interpretation. They do prosecution. They draft charges. They write opinions, both informal and formal. So on a daily basis, they are getting telephone calls with people state employees asking, can I do this? Can I do that? You know, that kind of, they're looking for informal advice, and they do that on a daily basis. And that requires statutory interpretation and a real clear familiarity with the ethics law, the lobbyist law, and the case precedent and prior commission rulings. So in that sense, I think that's the kind of experience that translates into quote trial experience, so to speak.
Well, thanks, Chair.
Thank you. Members, any other questions for Mr. Ho'okano or any other? Senator Ocasio, go ahead.
I have a Chair. I have a question for Mrs. De Guzman also, just kind of on that same topic. Do lawyers and attorneys follow these ethical rules and have continuing education surrounding ethics as well?
Okay, I'm not quite sure. The first part of your question was whether attorneys follow the ethical rules. What do you mean by that?
Well, meaning like, are they required to have continuing education, for example, on ethics, and also, you know, have that same standard, not only if you work in the ethics commission, but actually like attorneys in general?
Right, okay. You know, one of the core requirement or missions of the ethics commission is to provide education. And one of those components, the staff attorneys, including Dan, provide a seminar or an education session for attorneys, and they have gotten permission from the HSBA for attorneys to use the attendance of that training session for their bar certification. You know, they have to take ethics training. So that's one of the courses they can take, which the Ethics Commission provides. Did I answer your question?
Yes, pretty much.
Yeah, okay.
But is it mandatory and standard, or it's just an option?
Well, I think I'm not real sure. It's not mandatory because I think the attorneys can take other ethics courses that are presented by other people, other entities or whatever, but the commission attorneys do provide the option of doing the state ethics and lobbyist law.
Okay. But in general, they still need to have ethics training on a yearly basis. Just depends on where it's from.
Right.
Okay.
Yeah. Okay. But then it has to be like approved by the HSBA to count towards your, licensing.
Okay. Thank you.
Thank you.
Thank you, Senator Ocasio. Anyone else have any questions? All right, if not, let's take a brief break. Let's come back at 1:50 and let Mr. Gluck collect his thoughts, and then we'll hear from the nominee himself. So 3-minute recess. Thank you. Welcome back, everyone, to the Judiciary Committee meeting on 2 judicial nominations. Dan Gluck for the Intermediate Court of Appeals and Leslie Maloyan for the District Family Court on Oahu. We have completed the testimony for GM1, which is Mr. Gluck, and we will now hear from the nominee himself. Mr. Gluck, be ready. Please proceed.
Thank you, Chair Rhodes, Vice Chair Keohokalole, members. I am humbled and I am honored to be here today. I first want to thank the Judicial Selection Commission, the Governor, the Bar Association, this committee, and the Senate as a whole for considering my appointment, as well as to everyone who submitted testimony regarding my appointment. I want to thank my family, my parents, my wife Deborah, who's watching in the other room, my children, and my extended family, both here in Hawaii and elsewhere. I've struggled with how to open and address this committee. I've written and rewritten these remarks so many times. The list created by the Judicial Selection Commission for this seat was just incredible. The 5 other attorneys on the list have such impressive backgrounds. Sonia McCullen has been a friend of mine for the 18 years that I've been practicing law here in Hawaii. She clerked across the hall from me, working for Justice Nakayama while I worked for Justice Duffy. She's one of the warmest and kindest people I have ever met. I've worked with Lance Collins. He is a fearless advocate for his clients. Judge Kupao Odo and I also clerked at the same time, she for Justice Akoba. She has had a remarkable career. Malia Schreck's and Taryn Tomasa Gifford's resumes are equally stellar. Every single one of them would make a great appellate judge. That's why I was so thrilled that I made the list, let alone that I was appointed by the governor. Everyone who knows me or who has talked to me anytime within the last month and a half knows that I've been saying for weeks that I wouldn't be the one selected. Not because I'm not qualified, I am qualified, but because I shared the list with 5 phenomenal people. Their credentials are impressive. Their credentials don't make me unqualified. We are all qualified for this position. We wouldn't have made the list if we weren't. Granted, my legal experience is very different from each of theirs. Several of us clerked, including me. I was one of Justice Duffy's first law clerks and got to do 2 solid years of appeals with him. I was also one of Judge Seabright's first law clerks and got to do over a year of solid trial level work in federal court. Altogether, I had over 3 years researching case law and drafting opinions. After that, I went to a big downtown law firm, Alston Hunt. I did what any low-level associate did. I did discovery in a complex commercial case. I argued discovery motions in federal court. I spent hours upon hours slogging through document production. I had talented colleagues, I had great teachers, and I loved the frenetic pace of the work. But my heart was always in public service, and when I got a call to join the ACLU to work on civil rights cases full-time, I jumped at the chance. For over 8 years, I litigated civil rights cases. My first case was a class action lawsuit on behalf of homeless families. Some of you might remember Alice Greenwood. She was a fierce and tireless advocate for homeless people on the West Side, particularly Native Hawaiians who were homeless. She was our client. I worked with a group of lawyers from Alston Hunt, which is now Denton's, and Lawyers for Equal Justice. Together, we litigated a full evidentiary hearing in federal district court. When I was cross-examining a witness, I messed up the language to impeach her with her deposition testimony. Judge Gilmore called me to the bench and very politely instructed me on the right way to do it. I've never forgotten that. She could have yelled at me, but she took the time to teach me the right way to do it next time. I know what it's like to make mistakes in court. I know what it's like to have a judge be gracious when that happens. But we still won the motion. And the case didn't go to trial because instead of pouring our resources into litigating, we poured them into negotiating the best policy changes we could for homeless families throughout the state of Hawaii. If anyone out there has kids in DOE schools like I do, you might notice a bunch of forms relating to homelessness that you have to fill out at the beginning of every school year. Those forms, those are part of the systems that we fought to put into place 13 years ago, and they are still in place today, and they have benefited thousands of children across the state. It's true that in that case, I didn't get the litigation experience of taking it to trial. That was never my goal. My goal was to serve this community the best way that I could, to advocate on behalf of people who were marginalized, who couldn't afford their own lawyer, whose rights were being violated, to get long-lasting policy change so others wouldn't have to go through the same thing. My last case with the ACLU was another class action when the city and county of Honolulu was summarily destroying property belonging to homeless families. Our clients were Chukis, Yapis, Hawaiian, and poor. So heartbreakingly poor. But the city was violating their rights. We didn't argue then, and I wouldn't argue now, that anyone has a right to sleep on the sidewalk. But I did argue then, and I continue to argue now, that the law says you can't just destroy someone's property without due process. Again, the case didn't go to trial. When it became clear that we were going to win a pretrial motion, we were able to settle. We got the city to implement new policies that still protect homeless individuals today. Between those two cases, I represented all kinds of people in all kinds of cases. I worked on prison reform. I agree that there is systemic over-incarceration of Native Hawaiians. I worked on drug policy reform. I worked on marriage equality, women's rights, immigrants' rights. I was in federal court plenty. You heard about the Title IX case that we brought on behalf of the Baldwin women's softball team. I argued that case in front of Judge Ezra. There's a new softball field at the school because of our work. It is absolutely true that the other nominees on the list have more trial experience than me. It is also true that I'm the only one on the list who's run a state administrative agency. That doesn't mean I'm better or worse. It just means that I have different legal experience. Since I moved to the Ethics Commission 5 years ago, I've had a very different kind of experience in the law. I've supervised 10 people, including 5 lawyers who provide ethics guidance to state officials. Sometimes I have to resolve disputes between employees. I have to prepare our budget and appear before the legislature. We have to comply with the Uniform Information Practices Act, the Open Records Law, which might make me the only person in the state of Hawaii to have litigated a UIPA case against the state and also been responsible for responding to UIPA requests on behalf of a state agency. At the Ethics Commission, we deal with extremely complicated and nuanced issues. We write guidance memos that are clear and well-reasoned. Sometimes, as you all know, we have to tell powerful state officials no. We are also responsible for educating state officials on their ethics obligations. My colleagues and I have worked very hard to present dry regulations in a way that is easy to understand for all state employees. We also bring enforcement cases. As you all know, legislators are often favorite targets for ethics complaints. We get complaints against people, legislators and other state officials, whose policies and politics I personally agree with. We also get complaints against people whose policies and politics I personally disagree with. But we evaluate each complaint according to the facts and according to the law. If there is a violation, we pursue it regardless of our personal feelings. If there's not, we close it without partisanship, without politics. More than anything else, we are committed to being fair and impartial. In this capacity with the Ethics Commission, I litigated a 4-day contested case hearing. I oversaw the development and promulgation of administrative rules. As you know, a significant portion of the appellate court's work is administrative law. I've seen that firsthand. It is difficult legal work, and I'm very proud of the work that our agency does. One of the things I'm most proud of, though, is our legislative work. In my 5 years with the Ethics Commission, the legislature has enacted 8 measures strengthening our ethics laws. This session, the legislature passed and the governor signed a measure that puts into place a 1-year ban on lobbying for all cabinet level officials and a whole class of other high-level state employees. Now, none of these 8 bills is earth-shattering, but each represents an incremental improvement in the state of our ethics laws, and I'm very, very proud of this work. Again, I've done 5 sessions with the Ethics Commission. I've done 14 legislative sessions in total, and this legislative work, drafting legislation, testifying before this and other committees, negotiating compromise language, working with various constituencies, absolutely translates to the bench. I have seen the kind of work that goes into crafting and passing legislation. I know the kinds of compromises that you all have to make. It is hard to pass a law. And when you do, the language that you use is deliberate. If I can give a specific example for Senator Kim, I know that Senator Kim was very involved in SB 589, the UH Tech Transfer Bill. The bill was vetoed and an amended version was signed into law. The new version, the version that is in law, requires the Ethics Commission to review certain items. The legislature didn't say approve. The legislature didn't say consider. The legislature said review. That is what the commission will do, because that is what the statute says. As a judge, I will follow the law as you write it, not as how I think it should be, but how you, the legislature, have decided it should be. I know what goes into making the law. I don't always agree with the outcome of that process, but I will honor your work, the work that you do on behalf of the people, with everything that I have. I've continued to do pro bono work while serving as ethics director, including taking a quiet title case to the Supreme Court on behalf of my client, Ke'eaumoku Kapu. I've done that on my own time while holding down a more than full-time job and trying to raise 2 kids. I've mediated cases. I'm a middle child. I always prefer negotiation to argument. I've taught at the law school. I've taught and I've written about ethics. I've taught classes for domestic violence survivors. I've done everything I can to serve this community. Those are the values I bring to the court. That is the work ethic I bring to the court. That is the integrity I bring to the court. That is what I have to offer. I can only offer my service, myself, my experiences, and my character. I cannot change who I am. I cannot change where I was born. All I can control are my actions. I have spent 18 years doing all I can to serve these islands. I love this place fiercely and deeply. This is my home. This is my family's home. I was not born here, but I want to be buried here. The only thing I want is to serve this community in the very best way that I can. I am qualified for this position. I believe I have the skills, experience, and character to serve. But I rest knowing that if my appointment is voted down, there are 5 amazing, brilliant, talented people who can serve the people of Hawaii with distinction and honor. I am humbled and honored beyond measure to be here today, and I thank you all for considering my appointment.
Thank you, Mr. Gluck. Members, any questions? I know there's questions.
I do.
Senator Kim, go ahead.
I guess I'll start off. Aloha, Mr. Gluck. Sorry to meet with you, so I would like to questions that I would have asked you so everyone else can hear. I noticed that this is the only position you've ever applied for the courts. I see. Have you ever applied for any other?
So when I submitted the application to the Judicial Selection Commission back in November, there were 4 positions available. There was 1 opening on the ICA and 3 openings on the circuit court. And it's just 1 application, no matter which position you're applying for. So I'd applied for all those positions. The Judicial Selection Commission took this one first and put my name forward. I believe JSC is going to be interviewing for the first circuit court positions coming up in a couple of weeks.
Okay, but in the past, you've not gone for district court, for circuit court?
No, I have not.
So why the jump to ICA?
Honestly, Senator, I had been weighing whether or not to apply for a judgeship for some time. Finally, last year, I just decided to apply. I applied for everything that was open at the time. I think there is also a district court position open right now, but I just, I submitted my application for everything that was open at the time.
Okay, so if you're not approved on this one, will you apply for district court or circuit court, or is your preference ICA? I mean,
Honestly, Senator, I haven't given any thought to anything beyond this hearing today, so I'm sorry I can't really answer that for you.
Okay, because the criticism have been said that you lack a lot of experience, and certainly having served in other lower courts would certainly give you a lot more experience. And you've also passionately said that you want to serve and you want to be in public service. So I would assume the district court is where you touch the most people, and that's something that you would have applied for. So you went directly to the ICA or circuit court position. So I just, that just is curious for me. I have not had a whole lot of experience because I'm not an attorney. So as far as your court cases, but certainly while you were at ethics. And in particular, not too long ago, I contacted you regarding an issue at the airports as a conflict of interest. And you got back to me and said that you had spoken to a DOT staff who told you that contract workers, pursuant to their contracts, could have workspaces, and therefore you did not believe that there were any ethical issues. Did you actually review those contracts?
Senator, I can't speak to any work that the commission may have done that's not public. I'm prohibited by statute from discussing that work. So I'm sorry I can't answer your question right now.
Well, I don't want you to discuss the work in particular. I just kind of want to get a sense of your follow through, of your thoroughness. And when you state in your email to me, pursuant to these contracts, I just want to know whether or not you review the contract.
Senator, I'm sorry, I cannot answer your question in this forum.
So you cannot say yes or no whether you review the contract or not? I think that's
I cannot discuss our confidential investigations in a public forum, period. I'm statutorily prohibited from doing so.
Okay, but you did send me an email that's public, and it did say pursuant to these contracts, these paid consultants. And so if that's public, then can you tell me whether or not you actually review the contract?
Senator, I can't.
Well, for your information, it is not in the contract. There is no provision in the contract that says they are entitled to these workspaces. So, I'm just concerned about the thoroughness that went into your final decision to say that you did not believe that there were ethical issues that matter. There are other issues that we look at people that come before us for confirmation, and certainly your record and certainly our involvement with some of the cases that you may have done with us. And of course, it's very easy to always say, I cannot opine on this, or I cannot reveal, or I cannot talk about it because of ethics. And so I think that it's an easy way out, but there are concerns. And if you can't speak to it, then I'm going to have to make my own judgment based on my experience. There was one issue in your application that said United Student Aid Funds versus Daniel Gluck, a circuit court civil court case back in 1987. Can you tell us what that was about?
I'm sorry, there's a 1987 case?
Mm-hmm.
I was 11 years old, so I don't know what that is about.
Okay, well, it just says United Student Aid Funds versus Daniel S. Gluck. Maybe that's not you, it's another.
It's not, no, my middle initial is M.
Oh, okay, well, it was pulled up in e-court and it was included in our files for yours, so that's why I thought it was curious. Okay, thank you for that.
Yeah, I tried to do a thorough check of anyone named Daniel Gluck in the system, Senator, so I apologize for the confusion.
Okay, thank you. Thank you, Mr. Chair.
Thank you. Who would like to go next? Senator Keohkolole.
Hi, Dan. Can you, well, so because the discussion has come up so much and it came up a lot in the testimony, this distinction between lived experience, practice experience, trial experience, litigation, practical, professional. As a factor of qualification to this position on the ICA, can you define relevant experience?
I'm not entirely sure what you're asking, Vice Chair. Can you clarify for me, please?
There were a number of pieces of testimony in support and against that reference experience. And as you've seen in the dialogue that we've had going through the testimony and asking questions with the testifiers, there's this question of whether your record reflects what I would characterize as experience relevant to the task that you will be asked to undertake if you are confirmed. And so as it relates to that question, I'm interested in hearing from your perspective what you think relevant experience is.
Thank you, Vice Chair. That is helpful. So first, I would take a look at the nature of the work that the ICA does. The ICA has a very small handful of oral arguments every year, but the overwhelming majority of the work is reviewing the paper briefs and disposing of motions. And so the core of that work is legal analysis and legal writing. And I have 18 years of experience doing that, Vice Chair, in all kinds of different contexts, both as a law clerk in the state system, as a law clerk in the federal system, in private practice with the ACLU, as teaching law students with the Ethics Commission, and in my pro bono work. So, one of the things when I talked with Chief Judge Ganoza a couple of weeks ago, she was talking about the ICA and how it has this incredible breadth and complexity and variety of cases. And I've got, some experience in a lot of different areas. And I think my breadth of experience matches with what the ICA does.
So can you speak to those notions of the necessity for lived experience and how that relates to the legal history in Hawaii, which I think is distinctive compared to many of the continental, statewide traditions.
Mm-hmm.
And then the issue of practical experience. And what I mean by that is specific to appellate practice.
Mm-hmm. Let me first speak to lived experience. I hear and have heard for the whole time that I have lived here, that have been fortunate enough to live here, the passion and the pain and the need for better representation and diversity at all levels of state government. I absolutely agree. I mean, I think this is why this discussion has been so powerful and also, I think, so constructive because these are really valid arguments that we should be having as a community to try to address historic injustice and ongoing systemic racism. I agree with all of those things. I can only provide my own lived experience, right? I certainly can't stand in the shoes of anybody else. But as a community member here, as a father, I really treasure the values of this place. I am never going to have the same experience as someone who either was born here or someone who is Native Hawaiian. I can't. I never will have that. I only have my own experiences and my own commitment to be a fair judge who, again, it will promote the values that we have woven throughout our Constitution.
So I think that's a totally fair answer to the first part. So because it was a long-winded question, if I can ask you again the practical experience piece of this.
Sure. So as I said, I've done a little bit of a lot of different things. I've done pro bono. I've done, I think, 3 appeals in the last 5 years, including a cert petition, including an argument before the Supreme Court. You heard about that. In my ACLU time, we did a number of amicus briefs to the ICA, to the Supreme Court. I had one to the Ninth Circuit. I had one to the DC circuits. I had a petition for writ of mandamus that we filed. You may recall, I think it was 2014, there was the heated primary election between Senator Schatz and Colleen Hanabusa for the US Senate seat. And there was Tropical Storm Iselle that came and prevented residents on Hawaii Island from casting their ballots in the primary. And so we brought an original petition before the Hawaii Supreme Court to try to allow those ballots to be cast. We weren't successful in that challenge, but that's another one of the cases that I've done on appeal.
So I guess generally the answer is yes, you do think you have relevant practical experience. I guess if I can just ask a couple of follow-ups and then I'll yield because I asked like 6 questions in a row. But
Go ahead.
I mean, would you agree that well, actually, it's more of a question. I mean, it seems to me like the primary role of an ICA judge in this context is to determine errors at the trial court level. Is that fair? Have you,
yes.
in your appellate work, have you litigated trial court errors?
Yes.
Have you, okay, so, and so that's gonna be, so your case record will be indicative of that, the federal, your federal cases and state case record?
Yeah, I think the most notable example I have is the pro bono case I had to the Hawaii Supreme Court. So I first represented the client to the ICA.
Trial court errors sua sponte?
I'm sorry, can you say that again, Vice Chair?
Have you identified trial court errors sua sponte?
I'm not entirely sure how to answer the question. Certainly in that case, the trial court erred.
Sua sponte issues brought up in appellate practice. Maybe that's a easy, clearer way to.
Like, are there sua sponte issues that are brought up?
In your experience?
I know that, forgive me, Vice Chair, let me try and answer a slightly different question and see if I get to the question that you're asking. I'm not trying to evade. I just want to try to get to someplace that makes sense to me in answering this. I know that there's been concern recently about the appellate courts ruling on issues that weren't brought up by the parties. So to the extent that that is a concern, I know the judiciary is already working on rule amendments to try to ensure that parties have the opportunity to brief issues. So if you're talking about sua sponte, I mean, these are things that the appellate courts would be doing on their own. I mean, that's the very definition, is that they're addressing things sua sponte that haven't been addressed by the parties.
The governor had not taken action to veto legislation that we passed this year. I'm just asking if you have specific appellate experience on these issues. And if, you know, if you don't, then I think there's a question, and it's alluded to by the testifiers, about whether members of the bar who practice in this area will respect rulings that you will be required to make, identifying trial court error on behalf of the judge or the parties, or the possibility that you could just bring up, you know, sua sponte issues. But there isn't an established, in comparison to contemporaries, not to the short list, with your active years of experience, I would say it seems like there's less of a record here to give confidence to members of the bar that you are familiar with the specific issues of appellate practice.
Yeah, okay. No, thank you, Vice Chair. That helps to clarify quite a bit. So, I mean, in my 2 years clerking for Justice Duffy, I don't recall ever having an issue that we raised sua sponte that the parties had not had a chance to brief. I don't recall that ever happening. And certainly my intention and attitude as a judge is I'm not there to litigate the cases on their behalf. I'm not second guessing what the lawyers did. I'm not putting myself in their shoes to determine what arguments I could or would or should have brought. Instead, you take the arguments from the parties as they have brought them to you. Now, in criminal cases in particular, the court can notice plain error, but still the court can give parties the opportunity to brief those issues. I have every intention of doing that and not, bringing issues out of whole cloth and ruling upon them without argument by the parties.
Okay, yeah, I'll yield, Chair. Thank you.
Thank you. Members, any other questions? Well, let me ask a couple first, and we'll see if anybody else has any. So you touched on a little bit on your time with Chief Justice Duffy. I think you were there for 2 full years. Is that correct?
That's right. And forgive me, he was Associate Justice. He didn't get a promotion.
I'm sorry. No, I said you're right. I'm sorry. I misspoke. I was curious. 2 years. I mean, that's not unheard of to stay with one judge for 2 years as a clerk, but it's kind of unusual, isn't it?
Different justices had different practices. I believe Justice Duffy and Justice Nakayama had a practice of having clerks for 2 years. I believe Justice Akoba had a practice of having clerks for 1 year.
So you wanted to sign on for 2. I mean, I don't know if you had a choice. I mean, you applied different places, right? But you wanted to sign on for 2. You knew you were getting into 2 years. Why was the longer time frame more appealing?
Actually, no. I signed on when I first started. I signed on for 1 year, and after a number of months, I spoke with Justice Duffy and indicated I was interested in staying, and he said he wanted me to stay on.
Okay. So, what kind of assignments did Justice Duffy give to clerks?
It would be the entire case file with instructions to go draft the opinion. So usually what would happen? Yeah. So usually what would happen is that I would review the briefs, as would he. We'd get together and talk about how he wanted to rule in the case. And then with that direction, I would go back and do all the research and the writing to lay out the entire draft opinion. And then we'd have an editing process between him and me. Same process happened between my co-clerk and him. And then it would circulate to the other justices for their review.
Okay, so this is just probably more of a curious, which I probably shouldn't ask at this point in this late hour, but when you did the research for these things, did you have to, did you ever cite cases outside what the parties had filed? I mean, did you do additional research beyond just reading the cases that they had cited?
Yes. Yes, absolutely. I mean, anytime you're presented with a case, you've got two very different versions of what the facts and the law provide in a case. And so every time we would be doing our own independent research to see which side was correct or more likely than not, the result in the middle. We would also do legislative history research to ensure that we were ruling consistently with what the legislature had intended, if in some cases the language wasn't absolutely clear.
Okay. And were you required to attend the court's hearings when, I mean, the Supreme Court actually does have hearings as opposed to the ICA, but you had to go to those?
It does, but back then it was the pre-cert system, so all cases were going to the Supreme Court, so they didn't have very many oral arguments.
I see. But you were required to go to them when they did?
Yes, that's right.
Okay. So in terms of the actual decision-making process, I mean, when the justices would get together and kind of decide what they were going to do, and then the clerks got the direction from them, or did Justice Duffy discuss with you two to sort of make up to help formulate his initial take on where that case should go?
Definitely the latter. So we would meet with him and
before he met with the other justices.
Correct. Yeah, no, he was always open to the clerk's views on the matter. And so if we had opinions, we would share them with him, again, come up with a strategy for resolving the case. And I recall there was one case, and without getting into details, there was one where we were intending on going one direction and we ended up drafting an extraordinarily lengthy opinion. And then after it circulated and he met with the other justices, they decided to do something that was more restrained and came back with something much shorter. So there was definitely a process there.
All right, that's the end of that line of questioning. Members, any other questions? Senator Sin Buenaventura, go ahead.
Yeah, so thank you so much, Dan. You know, I really do agree that you are very sincere about your intent to focus on to help the downtrodden, and your opening speech was frankly really quite moving. My question is really, you know, well, I have a couple of questions. One is that you said that you applied. It's the first time you applied for a judge position, and you said you applied for three positions at once. Is that right? When Senator Kim was questioning you?
That's 4 positions at once. So there were 3 openings at the circuit court and then 1 at the ICA.
Okay, so 4 positions at once. So basically, because you were nominated for the ICA, you are no longer interested in those 3 other positions, or what happened to them?
I have an interview with the JSC for the First Circuit Court positions in a couple of weeks, Senator.
Okay, so basically, if somehow or other that your nomination here is not confirmed by the Senate for some reason or other, you still have the potential for being a circuit court judge in the First Circuit.
Yes, I suppose that's true.
Okay. So when I'm assuming that you have heard the testimony that has since the time of the hearing, and a number of people, and you addressed this in your opening statement, that you fully agree about the need for diversity and the need to address historic biases. And the reality is that even though, as Marty Townsend, Dr. Sproat, and others have testified, even though you are an advocate to prevent these historic biases, the nomination is really a symbol of this intrinsic bias by the governor in appointing women of color to lower courts, but not to higher courts. Do you see that?
I do very much hear and understand the argument, Senator, yes.
Do you agree with that?
Senator, as the nominee here today, I'm not in a position to speak to the governor's selection. I understand the question. I hear it. People have been asking me to withdraw here in testimony today. I feel that deeply. I really do. The best answer I can give to that, and it's not particularly satisfying to me, or I'm sure not to anyone else who's arguing today, is that if I'm to be a judge, then I follow the law. And what the law says right now is that the JSC comes up with the list, the governor picks from the list, the Senate advises and consents. And so I don't have, I can't speak as I sit here today to whether those choices were wrong or right. I think my part in the process was, the JSC says anyone who's interested in serving should apply. I was interested in serving and I applied. And after that, it's really out of my hands. And I understand that might seem hollow to those who are opposing with extraordinarily valid concerns. But if the issue is, to follow the law has a process set out. And if that process results in me being confirmed, then that's great. The process will have worked and I look forward to serving. And if the process results in me not being confirmed, then the process will have worked and one of the other nominees will serve.
Okay, so see that therein lies the problem, right? Mm-hmm. Is what Senator Keohokalole has pointed out. The practical experiences, because you are speaking as an academic, as someone who is going to go by the book and not see the culture and the reality of the practicalities of how this law is actually enforced. And the systemic biases that is occurring where the Kanaka Maoli is overrepresented in the criminal justice system. So isn't it kind of arrogant, for lack of a better term, for you to push for your nomination, knowing that there is an intrinsic bias, basically assuming that you in your higher position know better than the other nominees who are raised here and have the more practical experiences that you do not?
Senator, if I can address that last point first, I don't believe I've ever suggested, nor would I ever suggest, that I know better than the other nominees. They're all wonderful, incredible attorneys. I only have myself and my own experiences to offer. And I don't know that I can add any more than that. I think that the other concern, I know you raised that, okay, well, this is an academic legal question and it's not really about, that people should be, or I specifically should be more mindful of the lived experience and act accordingly. As a judge, there are going to be all kinds of times that I think the law should be different. I think the choices that are made by policymakers should be different. But it is not the job of the court to be making those decisions. It is the job of the legislature and the executive, and I would not intrude on that. And so I sincerely apologize if my approach has come off as arrogant or anything other than respectful, because what I mean to say in my testimony is that as a judge, the court has a role, and it is not the role to make policy. That is left up to the other two branches of government.
Okay, so I have one last question and then I will defer.
Senator, can I just follow up that real quick question on your question?
Okay, go ahead, Senator Kim.
Mr. Gluck, I just wanted to say that while you're following the law, by not withdrawing, the law also allows you to withdraw. The law, and it's been done before. So I just wanted to thank you.
Okay, so I just want to do my last question. Thank you, Chair Rhodes. And that is, I'm a lawyer like you. And my understanding of what judges do, and you're correct. It's not for the judge to determine policy. It's for the legislature to determine policy. But it is the judge's role to interpret that statute that we have passed in the legislature within the realm of the community and how it is enforced in the community. And therein lies the problem with your academic answer. My question was not academic. Your answer originally was, and I don't want to argue, belabor the point, but we're back to, if you really do truly believe in diversity and historic biases, and really the symbol of your nomination being shown here by the community as a symbol of the intrinsic bias of this governor in only appointing women of color to lower courts and not to higher courts, shouldn't you withdraw your nomination?
Thank you, Senator. I don't think I have anything to add to my last statement. I have expressed a willingness to serve. Whether I am qualified and will be confirmed to do so, I don't believe is my decision to make right now. I believe that's firmly in the hands of the legislature, particularly the Senate.
Okay, thank you very much.
Okay, Senator Casio.
Just as a follow-up on that, hello, Mr. Gluck, thank you for being here today. A follow-up to that would be, so then it is the Senate's responsibility in the selection and confirmation process to put a check on systemic racism?
Senator, the best answer I can give you is that it is not my place as the nominee to tell the Senate how it ought to do its job. The Constitution says advise and consent, and I would not dare to intrude upon that. So I leave the factors to be considered to you and your capacity as a senator.
Right. Okay. So similar question that I asked you during our interview, which was your position on affirmative action, and that you agree that diversity is an important requirement and qualification for the judicial system, especially here in Hawaii.
I believe very strongly that our judicial system, like all our branches of government, should be reflective of the rich diversity that we have here in Hawaii.
Okay, thank you.
Okay, let me ask a couple more questions, and then I'll open it up for more from other people. So from 2005 to 2006, you clerked for U.S. District Court for the District of Hawaii, Judge Seabright, and of course that's a trial court. Can you just talk a little bit about how the roles changed from being in an appellate court to being in a trial court at the clerk level?
Sure. The roles are still pretty similar, except that at the trial court level, almost everything is motions, right? So you've got motions for preliminary injunction, for summary judgment, motions to dismiss. You've got various criminal motions to suppress evidence and the like. And so rather than dealing with a firm record on appeal, you've got deposition testimony, deposition transcripts, declarations, other evidence that people are submitting to see whether the case is going to go through to trial. There was also one criminal trial that Judge Seabright presided over during my time as clerk. And so it's, the same, a similar kind of research and writing, and that Bruce would come in, and then the law clerks, a similar way that I suggested with Justice Duffy, is that we would meet with Judge Seabright, determine how he wanted to proceed with it, and then go ahead with drafting an opinion. So it's the same kind of legal research and analysis and writing.
And he required that you attend hearings and be in court when parties were litigating.
Yeah, we were in court one or more times per week with him.
Okay. And then you moved on, after that clerkship, you moved on to Elston Hunt Floyd and Ng, which was a private firm here in Honolulu. I think you mentioned that there was one big case that you worked on there. Can you just talk about that a little bit?
Yeah, it was a trade secrets litigation between two hedge funds where one was accusing the other of having stolen its proprietary methods. And so we represented the plaintiff in that case, and then there were counterclaims. So Much of my work was discovery related. We were just reviewing our own clients' documents, reviewing documents being produced by the other side, and then arguing over who had to produce what and when.
Yes, I remember those days. Okay. Okay, members, any other questions? Senator Keokolole, go ahead.
So to pick up on your practice experience, you list the Voluntary Legal Services Hawaii pro bono volunteer, or pro bono participation, and the UH Immigration Clinic. That was a year, and then you've been doing VLSH for 6 years. Do those correlate to your JSA application, the JSC application? Looks like you had 200 hours, more than 200 hours of pro bono services in the last 4 years. Does that all come?
Yeah, so whatever hours, I mean, all the VLSH hours are pro bono, all the UH refugee hours, those are all pro bono. So those would have been included in the tallies.
Okay, so that means in the last 5 years, outside of your Ethics Commission work, you've done the 3 cases for VLSH and then the 1 case for immigration.
Yes, I've also mediated a couple of cases. I'm trying to think if there was something else, but that's the bulk of it.
Okay, I just wanted to make sure that those connect. So at the Ethics Commission, you said part of your duties are as charge counsel. And then on your resume, you also list other functions of your position at the Ethics Commission include lobbying, supervising staff, being a spokesperson, general administration, which I assume is HR and budgeting and all that sort of stuff, and then developing educational materials. So those, besides the charge counsel work, it seems to me that the first 5 are non-legal in nature, and I'm wondering, redesigning the website. This was mentioned in testimony in your favor. Initiating Zoom-based ethics training, fixing the e-file disclosure forms, which I think you did a great job on, actually. And coordinating with the AG on the establishment of the anti-fraud reporting system. Those sound like administrative functions to me that I don't necessarily think you can say are legal in nature. In your time at the Ethics Commission, can you break down for me in terms of, those functions versus your functions as charge counsel and in other capacities where you are doing work that is exclusively legal in nature?
Sure. So if I'm talking about work that is giving ethics guidance to employees, which is absolutely legal in nature, enforcing cases, and teaching about ethics, I would include that as part of our legal activities. I'd say those 3 activities together take up at least 90% of my time.
Lobbying and all of your general administration take up 10% of your time at ethics?
I'm sorry. So lobbying is probably another 5% or so. I think the administration is probably about 10 or less. I'd forgotten about lobbying. That's another small part.
Okay. And then so at the ACLU, you also list in your time there, among other things, lobbying, supervising staff and volunteers. Ms. Perrin testified that you embarked on a multitude of missions to increase the visibility of the ACLU through press events and education for community outreach and litigation. Again, I'm wondering how you would break down those elements that I would describe as non-legal in nature compared to your actual work, litigating, however you want to break it down, pre-hearing or where you're standing up on cases. What's the breakdown of your time at the ACLU?
I'd say it's actually probably pretty similar to ethics, Vice Chair. I'd say it's probably 85% would be either reviewing cases to determine whether to bring them or actually litigating them or teaching about civil rights issues. Probably about, again, 85%. I'd say about 5%, maybe a little more on lobbying at the ACLU than at ethics was probably more of my time. And then the administrative aspects of it were 10% or less.
I gotta tell you, I have a hard time believing that, because I actually think that if this comes as a surprise, I think that you are an excellent administrator. I think the fact that as former chair of technology, to see that you have implemented 2 technology upgrades in 2 different organizations and managed all of the business process reorganization and change management and done them successfully already puts you outside of the norm of typical administrators in Hawaii, because the norm is for IT transitions and all of the associated administration and change management to fail far often than they succeed. And for you to manage those things, and then on top of that, lobby the legislature for 4 months a year, lobby the counties in your role at the ACLU, and then deal with the other general administrative duties that come with managing small offices, for you to say that that accounts for 15% of your time as an executive director, I just have a little bit of a hard time with that. The other thing I wanted to ask you about is, there's a deviation in your case experience between the cases where you list yourself as lead counsel versus co-counsel. Mm-hmm. And in the co-counsel situations, what percentage of the actual billable work, legal work that was done in just the co-counsel? Because I'm assuming lead counsel is, either exclusive or significant enough in coordination with other lawyers to say that that's all legal work. But when you were listed as co-counsel in these cases, what's your percentage of the billable work that was done?
So it really depends on the case, Vice Chair. So on
I don't want to monopolize all the time. Just generally, because there's just a handful of cases.
Sure. So let me think to the city homeless sweeps case that we did with Alston Hunt. I was working full-time and way more than full-time on that litigation from months before we brought the case all the way through until we had a tentative settlement agreement. Now, the lawyers from Alston Hunt were also litigating and also billing on that. I don't know what the percentages broke down for who did how many hours. I just don't know. I can tell you, though, from my own perspective, that the litigation I did, that was for a year plus, that was all I did.
So the lobbying, supervising staff, being a spokesperson, administration, developing educational materials, at least for one of those years at the ACLU, you didn't do any of that. You just did litigation.
So the last year that I was there, we had a separate we hired a lobbyist.
Or the executive director.
I'm sorry, can you say that again, Vice Chair?
Well, you had 7 years as staff attorney and then you had 2 years as executive director. So which year are we talking about?
So I was legal director rather than executive director. So in the last, 2015 to 2016, that year right then, I wasn't doing, we had another lobbyist that we had hired. And so she was doing the bulk of the lobbying during that time. I think I consulted on some of it, but I was not doing most of it. And you're right. I wasn't doing much of the other things because we were so focused on the litigation.
Okay. And then this is the last piece and I'll end it with a real question so that you can answer. In a letter that, Senior Judge Mulway from the federal court sent in on your behalf as a result of a request from the Senate. She indicated your exemplary work in 2 cases before her court where you prevailed and noted that, and this was also brought up by other testifiers, that the fact that you prevailed in those cases is indicative of your expertise because those cases did not go to trial. But isn't Miss Logan who testified noted that the ACLU turns down cases? And my understanding is that the ACLU, along with lots of other public interest law firms like Earth Justice, you selectively pick fact patterns and clients that not only provide a likelihood of success, but align with your broader policy prerogatives so that you can then take those wins, as you mentioned earlier, and parlay them into legislative action after the fact. So doesn't that piece of clarity as it relates to your experience deserve to be noted since we are having this discussion about discounting the case stats over your 18-year legal career because those numbers are so small? Part of the reason why they're small is the ACLU purposefully and deliberately cherry picks winners so that they can parlay those results for broader action.
Well, thank you, Vice Chair. So part of the job of the attorney at the ACLU is to screen these hundreds of cases that we've been talking about. And yes, we looked for cases that we thought would be impactful, not ones that we necessarily thought we could win. We did lose several cases, but we tried to find out what can we do. It's a nonprofit, right? We have limited resources, small numbers of people. So what can we do to try to impact the most people with the limited resources that we have?
I have more questions, but I'll yield.
Okay. Well, let me ask a couple more. And well, let me follow up on that one, actually. So when you're in private practice, did your firm take every case that was offered to you?
Well, I wasn't at a high enough pay grade to determine what cases were taken at the law firm, but I would assume no.
And in criminal defense cases, do criminal defense lawyers take every case?
Again, my assumption is no.
Okay. All right. Thank you. Let's talk about the ACLU a little farther. So that practice, was that mainly in federal court?
That's correct. Yeah, we had some cases in state court, some cases in administrative agencies, but most of the litigation was federal court.
Okay. So then, but then my recollection is that on the civil side, at least, the rules of procedure are almost identical in state and federal court. Is that correct? And if there are differences, can you point to some salient ones?
That has been my experience. I know that the state courts currently are looking at new rules of civil procedure for some discovery practices. I think Rule 16 and Rule 26 are under review. I don't know if it's to catch up to the feds or to surpass them. I haven't compared them side by side recently.
Okay. And well, as you're probably aware, almost all, well, I think you mentioned it before, almost all the ICA cases are decided on the briefs filed by the parties. And for the last pre-pandemic year where we have data, 562 appeals decided by the ICA, and the court granted hearings on just six out of 562. Mm-hmm. Some lawyers might find this focus on reading and applying precedent without basically any oral argument kind of dull. You think you're going to have any trouble if you know, assuming if you are confirmed, will you be able to adjust to that role?
Yes, I'm an introvert, so the idea of just being able to be in my office and read briefs and write about it, that sounds just about perfect. I also, just to address your point about the numbers of oral arguments, any party can request oral argument in a case. The ICA accepts some of those and rejects some of those, but it's still a pretty small number. And I think the reason is mostly due to the backlog, that parties don't want to slow down their case by asking for oral argument. They'd rather just have the court get to it as quickly as possible, reach a result, and then determine if it's going to be appealed to the Supreme Court.
Okay. Yes, and that's the other difference, as you mentioned, when you were at the Supreme Court, in the old days, all the cases went to the Supreme Court, and then they basically deferred ones that they didn't want to deal with to the ICA. I mean, I think they still gave them a ton of cases, but it was, in any case. All right, let's see, what else we got? Senator Senator Lee, go ahead. Thanks.
Just wanted to follow up on some of the questions Senator Kehoe-Kalole asked about the administrative side of things, but shifting to I think more of the policy side of the Ethics Commission in particular. I think some of our former colleagues are intimately familiar with that process, which is maybe why they're no longer here. But for many of us, and for me, it's still a little bit of a mystery box. But I mean, as it stands, the policy side or the functional side of that job with teeth, right? I mean, you basically are acting as an arbiter and judge, not just for specific cases that are brought before you where somebody might be doing something corrupt or unethical, for which you have an obligation to render judgment, but also when there's debates over what the meaning of statute is. And I can't remember how many cases like that have been brought forward, but certainly there have been a few over interpretations over what constitutes gifts and other stuff. I mean, how much of that was your job? I guess going off of what the senator was talking about, like what percentage of your time is looking at that kind of stuff?
Sure. So we get complaints every day. We get requests for advice every day. And I'm so grateful to the 5 other attorneys in the office who are working on these matters every single day. usually we'll have an attorney of the day. That person will take the inquiries as they come in. I usually get a couple requests myself directly every day that I respond to, and inevitably the attorney of the day will have questions about that. And so I will consult with that person to formulate the legal response accordingly. And then for the complaints that come in, we'll first screen them to see if we have jurisdiction over the matter. And if we do, then we'll determine how best to investigate the issue. If we're going to conduct a limited investigation, or if we're going to ask the commission to issue a formal resolution of investigation to go forward. We have, some cases they will come in and we'll see right away, oh, it's a complaint against a city and county official. We don't have jurisdiction and it's closed. But we've had other investigations that have gone on for years just because they're complex, or because we may be waiting for another agency to do its review and its work before we can take over.
And in your interpretation, I guess, of what the law says about where the boundaries are on ethics and so forth, have there been those kinds of cases that have come up recently?
Yes, absolutely. At the end of the day, it's the commission itself, the 5-member ethics commission. They are the ones who will set policy and interpret the law and decide how the ethics code is to be interpreted. So we advise the commission, but ultimately it's their decision. But we certainly have had cases recently. And usually you can see them in our formal advisory opinions that are published. Almost always what happens with those is someone will call with a request for just regular attorney of the day advice. And my colleagues and I will discuss it and realize that it's a particularly complicated issue, one that the commission should opine on. And so rather than us charting our own course and creating new rulings under the ethics code, we'll go through the formal process of having the commission issue a formal advisory opinion.
Has that ever appealed?
I believe that in the teacher chaperone case a bunch of years ago, I believe that, yes, HSTA appealed from an advisory opinion. And if I can give you a little context for that one. So you may remember this, before I started with ethics, there was a dust-up where the commission and previous staff had ruled that teachers could not accept quote unquote gifts of travel to chaperone students on their trips. HSTA sued in circuit court and won in circuit court. And so when I came in, there was a question of, well, do we appeal this matter or do we try to settle it? And my opinion then and now is that if a teacher is taking students on a trip, that's not a gift, that is work, and should not be treated as such. And so I was able to negotiate a resolution to that case with HSTA. There was still an ethics concern because some of these tour companies would give teachers extra perks, like extra travel rewards, iPads or things like that they could earn if they sold enough trips. And there was also a concern that parents and students might not know that part of the money they're paying for their own child, that part of that also went to pay for the chaperone. So the two things that we also negotiated as part of that was that for any future trips, that it would be disclosed to parents if part of the trip money was going to be used to pay for the chaperone, and also to prohibit teachers from accepting other gifts, other perks from the tour companies, so they wouldn't have an incentive to pick one company over another, but rather the cheapest and the best one for the school trip.
And that was like 4 or 5 years ago, right? Or something?
That was right when I started in 2016. Mm-hmm.
And then for the other, I guess, more notable policy change that was in the news for gifts and things like that, because it's an interesting position you hold, right? Because you're in part speaking truth to power in a way, right? I mean, the folks that you're asked to regulate, it's us, and it's the governor, and it's other state employees and so forth. I mean, I got to imagine that's as difficult as just about anything else that you'd find out there.
No, thank you, Senator. It's always a balance. Our agency, we're trying to promote the highest levels of integrity in state government that we can. We also acknowledge the reality of working conditions for state employees and also for legislators and how you all do your jobs. And so I know we've had discussions about the gifts rules. Weeks ago, prior to my appointment, I'd already started talking with staff about things that we can do to address some of the legitimate concerns that were brought to our attention. I said at the start of my tenure with the Ethics Commission, and I still feel now, that the best thing that we can do is to make the rules as clear as possible and easy to follow. People shouldn't have to guess what the law is and shouldn't have to guess how to comport themselves accordingly. There is still work to do on this issue. For the gift statute, we took a statute that was, a little bit long and turned it into 6 pages of administrative rules. It still needs more detail. We're still committed to working on that.
Okay, thank you. Thank you, Chair.
Okay, Senator Ocasio.
Aloha, thanks again for answering questions. As was noted earlier, since we're on the topic of ethics, I just wanted to ask a few questions. And it was noted earlier you were law clerk for Justice Duffy, correct?
Yes.
And then would you consider Justice Duffy a mentor or a friend in that capacity as host working for him?
Both, yes.
So another question would be, during this judicial selection nomination process, did you contact Justice Duffy, like before you applied or even after?
I think, I'm trying to recall my conversations with him. I don't think I contacted him before I applied. I don't think I contacted him at any point before the Judicial Selection Commission list came out. I don't know that we discussed anything before the governor's appointment, honestly. I can go back and check my records, but I don't recall having conversations with him about the appointment at any time prior to the governor naming me.
So it would be, if anything, would be after you were named as the nominee.
Yes, I've discussed the matter with him after being named. That's right.
Mm-hmm. Are you aware that Justice Duffy plays an advisory role on the governor's judicial nominations?
I am.
Yeah. I'll yield for now. Thank you.
Okay, Senator Keokalole.
So the Attorney General also testified in your favor and noted the closeness of your relationship. Credit for you coming out to Hawaii, actually, if I recall. Did you have any contact or discussions with her after you were selected by the JSC?
I don't believe so. I think she may have sent me a text to say congratulations on making the list, but I don't recall speaking with her prior to the appointment.
So I think that's fine, because I think I did that too.
I appreciate it.
The I think in noting Senator Ocasio's questions, the fact that both Justice Duffy and the Attorney General testified on your behalf in the record to the Senate, and also acknowledged that they serve in an advisory capacity on judicial picks. From an ethics standpoint, don't you think that at least the appearance of that seems problematic? In light of this discussion about fears of influence and the nature of the system that was brought up by some of the other testifiers?
Well, first, if I believe I'm correct about this, that Ms. Connors testified in her individual capacity rather than her official capacity. But otherwise, in terms of influence, I can't speak to that, Vice Chair. I just don't know. My role, again, is I went and once my name was on the list, I interviewed with the governor, and sometime thereafter, I got word that I was appointed.
I understand that, but you do acknowledge that the fact that they acknowledge that they are judicial advisors to the governor, and then also testified on your behalf in favor of your nomination before the Senate, it does create a problematic appearance. Would you not agree?
I don't think so, Vice Chair. I mean, I've known both of them for an extraordinarily long time, right. So I can't speak to the.
Which was part of the criticism that has been made by multiple testifiers earlier, speaking to the systemic bias issues of this process. And one of the testifiers specifically spoke to access to spheres of influence that were not necessarily available to other candidates that could play into these notions that the less experienced or the least experienced candidate was selected. And so as ethics director, I would like you to weigh in on that question of an appearance of impropriety.
Yeah, Vice Chair, I don't think I'm in a position to comment on the way in which the governor has made his selection.
You see, we talk about these systemic problems, but when they reach our doorstep, that's where the conversation ends. And this is the problem that I have. So I'd like to have more discussions about qualifications, but I have to ask you again to at least speak to the fact that these two individuals admit that they have influence with the governor on selection, and they testified on your behalf before the Senate. That seems like access and influence that the other shortlisted candidates do not have. And I think it completely validates these questions that there has been a lot of strong feelings on from your supporters that they are unfair questions about your qualifications. I think this specific issue begs those qualification questions. There is an appearance, I would argue, of that there's access here that could potentially have been utilized to allow you to be picked perhaps in front of other, as you've noted, equally qualified candidates. And so given the nature of your position in ethics, I'm asking you to make a statement on it.
So, Vice Chair, again, thank you for your question. I'm not here as the ethics director. I'm here as the judicial nominee, and I cannot comment on your
legal. It's a fundamental portion of your legal experience. It's 5 years out of an 18-year career where you just said that you spent 85 to 90% of your time doing administrative proceedings that are significantly legal in nature and are a fundamental part of your qualifications.
Sure, Vice Chair, I am fully capable of analyzing the law and giving you the legal explanation for how this sort of issue might apply under the ethics code, but I'm not here in my capacity as the ethics director. I'm here in my capacity as a judicial nominee, and I don't have any further comment on the way in which the governor made his selection.
I'll yield.
Senator Kim first, and Senator Ocasio.
Thank you, Mr. Gluck. I appreciate your last statement. However, you're not here as the ethics director. Your work during this period of time is partly on how we may evaluate you and how you react and how you go about making some of these decisions. So I think it's an appropriate question and should have an answer.
Thank you, Senator Kim. Again, one of the tenets that we have at the Ethics Commission, and it's a ruling that had come down actually from the Attorney General's office many years ago, is that if someone comes to us and asks whether someone else is violating the ethics code, we're not allowed to give an opinion on that. We can only give an opinion to the person whose actions are at issue. And so if someone comes to us and says, how do I comport my own behavior to comply with the ethics code, we can evaluate that. If someone comes to us and says, I think someone else is violating the ethics code, we will treat that as a complaint and we will evaluate that accordingly. But we can't give an opinion to a third party as to whether another person is violating the ethics code.
Well, I don't think the question was asking you whether somebody else, they're asking about you personally while you're on the ethics director. So I think, you keep hiding behind these so-called legal things in ethics, which is annoying to me, by the way. Did you ask anyone to send in testimony for you?
I'm sorry,
for today, did you ask people to testify for you today?
Yes, of course, Senator.
Did you ask the AG and did you ask anybody else?
I did not ask the Attorney General, no.
Did you ask anybody else within the governor's?
Within the governor's office? No. I didn't ask my staff. I asked friends and former colleagues, but no, I would not.
Okay, thank you.
Okay, Senator Ocasio.
I yield, Chair.
Okay, any further questions? Senator Keokalole.
Okay, so I'm gonna go back to experience. A noted local litigator testified today on your behalf and spoke to this issue of the lack of trial court experience compared to the other shortlisted candidates, and noted that he testified in favor by saying, I know people have said Dan does not have enough experience or that his work has been too limited. Those concerns are unfounded. Legal skill is not a function of quantity or repetition. Handling lots of routine cases means nothing when it comes to judging the hard cases that end up on appeal. So this was brought up a number of times in the first third of this hearing. That same noted local litigator said in 2018 to Civil Beat, quote, "It is a bad thing to take a lawyer who has never been a litigator and say, now you're going to be a judge. I think that the pool you want to draw from in selecting judges is people who have litigation experience." So for you, which one is it? Or are you an exception to both rules that allows them both to coexist at the same time? And this not to seem like an inconsistent perspective.
Thank you, Vice Chair. I have litigation experience, which I've discussed, and I'm proud of my record of litigation experience.
So I'm asking you to speak to the statement.
I think the best answer I can give, Vice Chair, is that to repeat what I said before, which is that it is not my place now to determine what makes a good judge and whether someone ought to be confirmed. That decision is firmly within the hands of the Senate. I think from my own perspective, having worked for two judges, having litigated in court and see the kinds of skills, I believe very firmly that I have the skills and experience and temperament to do it.
But without things like case statistics, there's no body of record for us to go off of to determine whether you're qualified or not. The Bar Association just admitted that they didn't really look into the scope and the depth of your, litigation experience outside of court records. You have contemporaries on the short list who know, like you do, that their specialties are constitutional law, civil litigation, appellate process, who have orders of magnitude more case experience reflected in the records. And so we're left in this position where there's this gray area that we all acknowledge exists as it relates to your record of achievement. And we have to take the word of the folks who testify in your favor and then weigh that against testimony from members of the bar who have come in opposition and openly said that they are afraid of retribution for speaking out against a member of an appellate court who stands in judgment over potentially trial issues that they litigate. I think it's problematic that you haven't been willing to answer some of these difficult questions. And I'm not sure how else to say it. You know, part of the reason why there's a 10-year minimum active experience requirement before you can apply to a judicial position is this notion that it is difficult in the scope, in the breadth of practice of law to determine whether somebody's experience is relevant enough to do the job. But in your situation, it's difficult to quantify, and then you've refused to speak to some of these specific issues. And so we're kind of back to square one, where years of service really do matter. And the high court judges who sit now, by and large, have decades of experience that correlate to case records that are very substantial to buttress that. And I just think that this speaks directly to questions about qualifications and whether we have enough to go off of to make a determination as to whether you deserve to sit or not. Absent all the other intangible issues that everybody has made clear. I don't dispute the fact that you're a nice guy. I attest to it. But there's a record here that's absent, that it's difficult for us to ignore in the context of your nomination in the moment. Wouldn't you agree?
Vice Vice Chair, I disagree with the contention that I haven't answered questions about my litigation experience. I think I've been very forthright about my litigation experience, and I've provided materials to you and other senators with greater detail about my experience. I have also been clear that my experience is very different.
I mean, you noted, I think 20 cases total if you take into account the federal, maybe 25, the federal litigation. But what I've heard over and over again from Ms. Perrin, who supervised you at the ACLU, Mr. Guzman on the ethics, is that we need to note all of the things that aren't coming up in the case records, all of that work, on top of all of the other things you do, lobbying and press conferences and education and administration. So we just need to take what they say as fact and then move forward. And so where is all of that information? Where is something that we can look to get a determination as to whether that's valid or not?
Yeah, well, that is very easy, Vice Chair. You can go to the Ethics Commission's website, and we have every formal advisory opinion that we've issued since I started, and then some. Those are all up on the website. Every resolution of charge or resolution of investigation, those are all up on the website. And there are, I don't know, 60, 70 cases, resolutions of investigation since I started, another 40 or so formal advisory opinions since I started. So you're welcome to look at all of those. I encourage you.
And at the ACLU, where people are saying you're doing a lot of work, it's not reflected in the case counts.
Yeah, well, as we've discussed, a significant amount of the work is reviewing cases in the first place to see whether we're going to bring them. And I also, you know, I can't even count the number of cases where I had a complaint that I'd written up that was ready to go, and then for some reason it fell through. Either the client flaked out, or we discovered some other piece of information about the client where we decided that there wasn't a case to bring. And it also, as others have discussed, you know, we had other cases that we resolved without resorting to litigation. If I can give one example, you may recall the APEC conference, the Asia Pacific Economic Cooperation Conference that was here in 2011, I think. That was, you know, President Obama came, other heads of state came. As far as I can recall, there was no one arrested as a result of a peaceful protest. There was no litigation stemming from those protests. And that is because we had done work ahead of time with the police departments. We had meetings with the police, we had meetings with federal authorities to try to work out where people could protest and not get into trouble. Because my goal was always, like, I don't need to go to court to make this point. I'd rather have the people be able to have their protest. Like, I'm much more concerned about the result than I am about getting into court and making a splash there.
So my point is, how is that any different from the records of the other shortlisted members who also had to deal with indigent clients and follow up with folks and try to resolve things out of court, but also have all these years of trial experience?
Yeah, as I said, Vice Chair, I think the other candidates are wonderful. I have nothing, absolutely nothing negative to say about any of them.
Okay, thank you, Chair.
Okay, it feels to me like we've all made our points several times, including myself. Can we go ahead and end the questioning of Mr. Gluck? Okay, we will go ahead and thank you very much, Mr. Gluck, for spending these quality 4 hours with us. And we'll come back to pick up JC1, which is Leslie Maloyan for District Family Court at 3:30. 3:30 we'll restart. Thank you.
Thank you all very much.
We're in recess. Okay, thank you, everyone. This is still the Judiciary Committee hearing that started at 11 a.m. We are now completed with Governor's Message 1, which was Dan Gluck for nominated for the Intermediate Court of Appeals. I forgot to mention it before we went into recess, but we're going to vote. We're not voting today. We'll vote tomorrow at 10:30 a.m. And that will be via Zoom and there'll be a YouTube live stream. Okay, let's move to the second nominee, and that is Leslie Maloyan for the First Circuit District Family Court position. And first up for her, on her nomination, is Darcia Forrester. And I see you, I don't hear you. There we go. Afternoon.
Aloha, Chair Rhodes and members of the committee. My name is Darcia Forrester, and I did submit written testimony in support, but I did want to take a few moments to speak on Leslie Maloyan's qualifications and experience. I have worked with Leslie for over 15 years at the Office of the Public Defender, and she's both a colleague and a very dear friend. I strongly support her nomination to the judiciary. She is a very talented and experienced trial attorney, and she is a dedicated public servant. She is also a fantastic mother to her son, Kane, and her daughter Kaya, who are watching the hearing from home today. Leslie is exceptional in so many ways that can only benefit the judiciary and the state of Hawaii with her appointment. I have long admired her work ethic, her intelligence, and her ability to manage a heavy caseload, her case management, the challenges of trial work, and her ever-present professionalism. She is a natural-born leader, and I have no doubt that she will bring her many talents and her dedication to lift up and support the judiciary's mandate. I have every confidence that she will emulate and promote fairness and justice in the district and family courts. I strongly support her nomination, and thank you very much for the opportunity to speak today. Mahalo.
Thank you. Thanks for waiting around so long. Next up is Sandra Sims, retired Judge Sandra Sims. There you are. You're still muted, though.
Good afternoon, Senator, and thank you for the opportunity to be here to speak on her behalf. I did submit written testimony, and I'm pretty much relying on that, and I'm looking forward to having the opportunity to welcome Judge Maloyan to the family court bench, and I hope you will look favorably upon her nomination. And I think, as you all probably all know, we are certainly looking at, she has certainly the qualifications, but I think she brings something to the bench that we are indeed seeking to have, and that is a diversity that reflects our entire community, and she brings that as well. So thank you for the opportunity to speak on her behalf, and I will yield to anyone else who wishes to testify for her.
Thank you very much. Next up is Daphne Barbie Wooten. Hello again.
Thank you. Hello again. I too am testifying in support of this nomination, Leslie Maloyan. I'll just say one thing. I used to be a public defender. I only lasted 4 years. Well, I looked at the resume of Leslie, and she lasted 18 years, and that shows perseverance, a lot of dedication, exactly what is needed for the family court. So I hope you vote favorably. And again, as been mentioned, throughout this hearing, the prior hearing and this hearing, diversity is very important in the judiciary, and she brings that as well. Thank you.
Thank you. Next is Scott Spallina.
Thank you, Chair Rhodes. My name is Scott Spallina. I'm with the Office of the Prosecuting Attorney here in Honolulu, Hawaii. I've been doing the job for about 25 years, and I've known Leslie for approximately, her entire time at the Public Defender's Office. I'm against her all the time, basically. She sits on the opposite side of the courtroom, and I've seen firsthand her dedication to her job, the experience that she'll bring to the bench if she's nominated or she's selected. She shows every day that I've seen her common sense, reason, and a good understanding of the law. If she's chosen to the bench, I believe in everything that I believe in, that she will have common sense, she'll follow the rules of court, and she'll follow the intent of the laws. And as a purely selfish reason, I hope that you do select her to become a judge, and that I'm tired of losing to her. So hopefully she'll make it onto the next stage.
Thanks very much. Okay, so members, that's all, except for HSBA, that's all the testimony where the person asked to zoom in. So do we have any questions for any of these testifiers? Okay, I don't either, so let's go ahead and move on. The remaining testimony, Voltaire Gonset in support, Jackie Esser in support. I'm sorry, all these that I'll be mentioning here are in support. Taran Tamasa, Okechukwu Oki Amadi, Sat Hala Friedman, Alan Komagome, Henry Ting, Melanie Veltri, Allison Karkin, Paige Ogata, Titima Ea Taasa, Aubrey Bento, William Bento, Jessica Domingo, Charles Crean, Lee Hayakawa, Antoinette Lilly, Stephen Nichols, Evan Tokunaga, all in support. Haley Ching, Doris Lum, Jacqueline Dyer, Jason Morio Onishi, Phyllis Hironaka, James Tabe, State Public Defender, William Bagasol, Jerry Villanueva, Melinda Garma, Sheena Crail, Saisamoa Gray Price, Trisha Nakamura, Nina Key, Leslie Matthews for the African American Lawyers Association of Hawaii, Edward Young Jr. All those are in support. Ario Keopualani Ani Angwai, testifying for Lyra Organics, is in opposition. Indole ACP in support. Alfonso Braggs in support. And that brings us to Levi Ho'okano, President HSBA, and thank you for hanging around so long.
Aloha, Chair Rhodes, Vice Chair Keohou Kalole, members of the Senate Judiciary Committee, long time no see. We are testifying and commenting on Ms. Leslie Maloyan. We followed our usual procedures. We interviewed the nominee, checked her references, checked her background, and we did find her qualified. Ms. Maloyan has experience in family law, having served as guardian ad litem, as well as doing other family law cases, and her extensive experience in the public defender's office demonstrates her commitment to public service and helping those who have trouble helping themselves. She also handles highly complex and emotional cases to be able to handle the type of pressure that she would experience on the family court bench. Her references included members that she litigated against in the prosecutor's office, and all of them were very supportive of her nomination and of her qualifications to sit on the family court. If you have any questions, I will be available for you.
Thanks so much. Members, any questions? Seeing none. Ms. Maloyan, would you like to make an opening statement?
I think she's having technical difficulties, Senator.
Okay. Well, we'll wait for the technical difficulties to work out, I think. There we go.
I'm sorry, I thought that you were going to unmute me.
I think you're unmuted.
Good afternoon, Chair Rose, Vice Chair Kalole, and members of the committee. Thank you so much for taking the time this afternoon to consider my confirmation. I'm very happy to be here. And please introduce myself to the members of the committee that I have not already met to discuss my qualifications as well as to answer any questions that the committee may have. This has been a very exciting time for myself and my family. They're watching, they continue to text me. They're just so very proud of me. And I am also very proud and very happy to be able to be here to demonstrate to particularly my daughter that there is no limit, that she can achieve whatever it is that she sets her mind to, that she can be strong and that she can be smart and intelligent and that she can set goals and that she can work very hard to achieve those goals. So once again, I am open to questions. I'm happy to discuss my qualifications and answer any questions that the committee may have.
Thank you very much. Members, any questions? Senator Gabbard.
Yes. My question is, what is the biggest challenge that you see at family court as a family court judge, and then how would you go about helping to address that challenge?
Oh, thank you for that question, Senator Gabbard. At this moment, the biggest challenge that I see personally for myself is to ensure that I am up to speed on whatever the family court rules currently are, what the law that is applicable currently is, so that I can be a competent judge and that those folks who come before me leave feeling that they were treated fairly, with respect, that their issues are properly considered and weighed and resolved. So To do that, Senator, what I've been doing is trying to get myself ready. And that is, I have already read the family court rules. I have a copy of the divorce manual that I have read as well. And one senator gave me a tip on a video by William Dara. It's a tip mostly for pro se litigants who come before the family court, but I found it very helpful to watch the video in order to understand what our pro se litigants are going to be thinking when they come before me. And I found it very interesting as well in terms of the basic tenets of the law that was expressed in that video. So I watched that and I did find it helpful. And these are all just the ways that I've been trying to get myself ready to be a competent judge who can weigh the issues, consider the issues, and make rulings that are in accordance with the law as it is written, and resolve the issues that come before me. So I found that to be my biggest hurdle, because I have been, as you have my resume, been with this office for many years. I did practice civilly, but that was many years ago. So I do need to get up to speed, and I found that to be my biggest hurdle, and I sought to address that immediately.
Thank you, Leslie. Thank you, Chair.
Any other questions, members? Senator Kim.
Thank you. Thank you, Leslie, very much for applying for the district court and for bringing diversity to our courts. I noticed that when you applied for the district court, did you specify family court, or is that something that the CJA just put you in? Is that an area that you wanted to be in?
At the time, Senator, I did not specify family court. I just specified that it was a district court position that was open. It wasn't made clear exactly which position that was open. And so I just applied for district court. And I find myself now being asked to go to family court. And I'm glad that you asked that question, because I don't have a problem going to family court. I do have experience there. Albeit it was when I did civil work, but I do have experience there. So I don't have a problem going there. If that's where the need is, my passion has always been to serve, as you can see from my resume. And so if there's a need in family court, I have no problem answering that call, going to family court, and addressing whatever needs to serve the people of Hawaii there.
I realize there is a great need in family court, and we certainly need to have compassionate judges, and I especially think we need to have compassionate mothers on the family court as well. But I also looked at your resume, and having been with the public defender's office, I think the district court, you would also do very well in our people's court, in just general district court. So I guess I just kind of want to know your passion, if it's more in the family court or more in district court. And I know that he can probably move you at some point in time, but you feel that family court is where you really want to be?
Well, Senator, I feel that I am willing to serve wherever there is a need, because as I said, my passion has always been to serve. So if the need is in family court, then I'm happy to go there in order to serve the people of Hawaii, because my career that has spanned so many years, so many decades, it has been in service. I have done public interest, and that's where I started, and that's where I hope to remain. And that is because I have always wanted to have a direct connection to the people that I was working with and have nothing in between, no degrees of separation. That way I'm able to connect, and they're able to connect with me. And I've always hoped that I have made a positive impact on those that I have come in contact with. And through public service, since we are able to directly interact with those that we assist, it has enabled me to reach out more, to have more, I guess, outreach, and has enabled me to, as I said, connect and relate to people from all walks of life and very diverse backgrounds. And I feel that I have benefited because I have learned so much from interacting with all these different people. And as I said, I can only hope that my interactions with them have been positive as well, that in some way, shape, or form, I have helped and left them in a better situation than when we started. So to answer your question, I am happy to serve the people of Hawaii. If the capacity in which I'm being asked to serve is in family court, I have no problem in doing so.
I think family court is such an important position. What kind of judge do you think you'll be? I always ask that question. What kind of judge do you think you'll be? Tough? Do you think you'll be easy? I mean, what in your mind, what kind of judge you aspire to be when it comes to the district court?
I aspire to be a judge who is patient, who is fair, who allows the litigants to fully state their position and fully state their case, who is respectful, who, because of my trial litigation background, I'll be able to understand what the issues are. I won't be persuaded by rhetoric or issues that have no bearing. I'll be able to focus in on what is important. And I also want to be compassionate and empathetic. And that is what I aspire to. But I also understand that a judge has to be objective. A judge has to be neutral, has to be fair and impartial. And so I aspire to those qualities as well in order for me to hear these cases, because you're so right, Senator, in that family court is already emotionally charged. We're finding these people probably at their worst. They're coming to the court with issues that are so personal to them. We are making decisions that affect the most intimate portions of their lives, their children, the dynamics in the household, whether they can have contact with each other, speak to each other. These are issues that are so personal and so close to home that it's high emotion. And so as a judge, I will aspire every day to be patient and understanding and neutral and respectful of the fact that these individuals that are coming before me are struggling with their issues, and they do need understanding as they present themselves to the court.
There are times when, you know, women are subject of abuse and so forth, and time again, you know, the person applying the abuse and so forth are let go only to find out that they end up killing the spouse at some point. So are you able to also be tough on some situations where you need to make that tough decision in protection of the family, the children?
I don't think that I would have a problem with that at all, Senator. Those are tragic situations. We hate to see those kind of situations or to deal with those types of situations, but if we have to, we do. And I believe that on a case-by-case basis, I will analyze each different case to determine what is best in this particular case based on the facts, based on the evidence, based on the law that is currently written, and that I will apply as it is written, and make determinations that will protect society and the families, and will work the case towards resolution. So I don't see myself as having a problem dealing with tough cases as well as dealing with simple cases. I think I'll take every case on a case-by-case basis. I think that I will listen and talk to the parties, review the evidence. I think that I will weigh and consider everything that is brought before me in order to make a decision that is appropriate for that particular case.
Thank you so much. Appreciate your answer.
You're welcome, Senator.
There's any other questions? I do have one. As we discussed before, we were talking about adjudications involving decisions to address an individual's mental health condition, including petitions for involuntary commitment, assisted community treatment, and guardianship. I guess the most fundamental question is, do you believe that the Assisted Community Treatment Act is constitutional?
Senator, I think as a family court judge, weighing on the constitutionality of different laws will not be within my purview, but I can tell you that this particular act, as far as I know it, it allows family members who are concerned about their loved ones who have mental health issues to file a petition, as well as social services individuals as well. You know, different people can file petitions, and once a petition is filed, a hearing date is set, a GAL is appointed, and that person is responsible for assessing who is now the respondent and reporting that assessment to the court. And that assessment obviously contains information about the individual's medical history, mental health history, their current living situation, housing, finances, a global report that allows the sitting judge to make a detailed ruling in regard to that particular case. And the GAL will then make recommendations that are what's in the best interest of the individual, free from that person's preference or desires or wishes. And in that way, the court can make a decision. The process, as I understand it, goes forward. If it is a contested hearing, then the judge will hold a mini trial. If the hearing is not contested, then the judge is able to implement the treatment plan that was recommended by the GAL as well as the evaluating medical personnel. So, I mean, that's as I understand it, and the need for it is great.
So you wouldn't have any problem ordering someone after the legal hoops had been jumped through, ordering someone to take a medication?
I think that you said that very well, Senator. So long as the legal hoops have been satisfied and the requirements of the statute have been met, I will not have a problem with issuing an order where which implements whatever treatment plan has been assessed, evaluated, and recommended by the medical personnel.
So, but well, we'll see if you ever get put on special calendar, which I think it'd be very interesting myself. But if you ever get put on one, you might actually get a constitutional challenge at family court, which probably would be appealed because litigants would want to see what the appellate courts would say. But I'm not sure you'll be able to avoid ruling on the constitutionality of it. Well, assuming there is a case on appeal right now, and maybe when that is complete, then we'll know the answer and there'll be precedent to follow. Okay, members, any other questions? Okay, well, hearing none, thank you very much, Ms. Maloyan. And we are, as you may have heard already, we're not voting until tomorrow. And now I can't remember what time it was.
I believe 10:30.
Sounds right. Yep, 10:30 via Zoom. And I believe we'll give you you and the other nominee the Zoom link for that meeting, and so you can come and follow along. And I think that's it for today. So I believe, I'm not sure whether it's an adjournment or a recess. We'll call it a recess till tomorrow at 10:30. And thank you all for being here and sticking with the process for these many hours. See you tomorrow. Mahalo.